My lord, I am seeking for permission to move, I mean, for listing of the matter tomorrow, my lord.
What is the urgency?
My lord, urgency there, man has been taken by the police, they are not telling about the hours.
My lord, due to my heart beating problems, I am unable to prepare my case as I have undergone surgery, heart surgery. So
Oh, is it heart surgery?
Yes, I have
Okay.
So it is difficult on my part to argue the case.
Okay, which matter?
My 4 and 5, my lord.
4 and 5. Okay.
Next week maybe.
Okay, it goes after 2 weeks.
Yes.
4 and 5, 2 weeks.
Please, Your Lord. It is concerned from the other side. I get to mention item number 11 also for adjournment.
11, we are not adjourning. Without advance notice, we are not adjourning. You'll have to wait for some time. We may not take it up, but still, wait, slip is there. Okay. 3, 6, 7, and 11. Okay. Adjournment slips are there. 3, 6, 7, and 11. Okay.
There's a lot of that. May I pray for listing of two XP matters after 10?
Listing, please give it to the court master. Let them take a call.
Item 13, supplementary list for motion.
In this matter, we are required to issue notice. In this matter, we will be required to issue notice.
It is fine. No problem.
Is he none?
But,
I'm fine. Please. Case register form. The entry course of the case register. On instruction. No police case has been registered. Checks me.
There's no representation from the land council for the from the petitioner. Next para. However, same line. However, Mr. P. Sharma, under the additional senior government advocate, is present. Next para. In view of the grievances raised in this writ petition, specifically projecting that the petitioner was taken into custody by the Dismissal police station on 9/4/2025 on the strength of a GD entry and thereafter released on 10/4/2025 must have, however, by way of coercive action, petitioner was made to sign checks towards settlement of purported dispute.
My name is
The court is inclined to issue notice returnable on, give a date after 2 weeks. Returnable in. So and so. Extra copies of the writ petition be served on the learned additional senior government advocate in course of the day. Next para. The officer in charge of this police station, within bracket respondent number 4, is directed to produce a copy of CCTV footage of the said police station on and from the evening of 9/4/2025 till the petitioner, namely Bikul Bora, Bikul, Bikul Bora, was allegedly released without registration of a case. Stop. The respondent number 4 and 5 are also directed to submit their response on or before the next date of listing. Next para list on so and so. Next para before the date of listing tonight, the learned senior government, additional senior government advocate shall transmit a downloaded copy of this order to the to all the respondents to bring the order to the notice of the said authorities. You are there? Okay, your name?
Bandana Das.
Miss
Bandana Das.
Bandana Das. Okay.
I'm on request of Mr. M. Shoyu.
Bandana Das, advocate on behalf of the learned counsel for the petitioner. Okay.
Supply item 14 for motion.
My lord, I have taken the instruction. In fact, yesterday and third day, my lord, they have routed the entire case from IG prison to Home Department to IG border, then to SP Karimganj, my lord. They have the SP Karimganj should take whatever necessary actions, my lord. Within this period, he will be sent back. No issue, my lord. Within the period specified in the.
Because they also have to give us a date so that we can book our tickets.
No, because probably, my lord, we have to hand over them to the, my lord, yes. The embassy of, my lord, their embassy, then they will send back.
Mr. Agarwal is right, because they must have time to book the tickets and travel
Yes.
back.
No, first of all, my lord, by whatever possible manner, my lord, we'll do as fast as possible. Before that, my lord, I cannot exactly. I'll talk to him whenever they will, my lord, give me.
Convey
that,
to you, you will convey to him. Okay.
Yes.
And we provide that we take the matter up next Friday.
Yes.
Hopefully everything will be solved by then.
Before that, it may be possible, my lord. Before that.
Okay. And the second is, if in the event
Yes.
you have to provide, if the protocol says that he has to apply with a mobile,
Then,
then we also say
yes,
that this will be an exceptional circumstances and would not be considered as a violation of the jail manual.
yes, my lord. Then your lordship may pass order, my lord.
Okay, then there will be no hitch.
Yes, my lord. Then there will be.
Okay. Yes. Mr. D.K. Agarwal and counsel for the petitioner is present. Next para. Pursuant to order dated 4/6/2025, comma, the Mr. J. Pang, comma, Leonard's standing counsel for the Home and Political Department. Home and Political within bracket B, bracket department. I submitted that he had spoken to the concerned officials of the Home Department as well as the Superintendent of Police Border, Karimganj. And he has been informed that the authorities in the Home and Political within bracket B, bracket close department, comma, Government of Assam shall do the needful to ensure that that by the next date of listing, comma, they will take appropriate measures so as to facilitate the any applications that is required to be made by the petitioner so that the petitioner can exit the country within the validity of the what certificate?
Emergency travel.
Emergency certificate issued by the
Embassy of Nigeria.
embassy from the Embassy of Republic of Nigeria.
Republic of Nigeria.
Next para. While appreciating the effort taken by Mr. M.R. Adhikari, Leonard CGC, as well as Mr. J. Pang, Leonard standing counsel for the FT matters, the court is inclined to provide that if the requirement of the protocol for travel of the petitioner out of India requires that he should use a mobile, comma, the authorities of the transit camp, Matia Gwalpala, including the Home and Political B Department, comma, Government of Assam, shall provide mobile phone and connectivity to the petitioner to do the needful. Full stop. As the same is being done, as the same would be done by virtue of the orders passed by this court, comma, the facility so provided to the petitioner shall not constitute a violation of the jail manual. Next para. We hope and trust that by the next date of listing, the concerned officials of the political and Home and Political within bracket B Department, Government of Assam, and the Foreigners Regional Registration Office, Kolkata, shall take note of the fact that the sentence against the petitioner has already been served and he's presently suffering illegal detention of more than 1,500 days, or nearly 1,500 days. And do the needful in right earnest with all urgency so that the petitioner can exit the country within the validity of the travel certificate. Next para. We request the learned CEC as well as the learned standing counsel for the FT matters to transmit a downloaded copy of the order to the respondents so as to do the needful. Next para. It is also provided that if there is any further requirement in the applicable protocol, comma, which is not made a part of the orders passed from time to time by this court, comma, the orders passed by this court shall not be construed as in the negative so as to um, so as to refuse to do the needful, comma, as may be required for facilitating the exit of the petitioner from the country. Correct?
MEA also will extend all possible help.
Huh?
Ministry of External Affairs,
Okay, full stop.
they
The-
also be recorded.
In this regard, the Ministry of External Affairs shall also do to extend all facilities and to do the needful in to give effect to the order. Next para, list on next Friday,
13/6.
13/6/2025.
Published.
Much of.
Acha, may I also make a mention so that it can be easy for, though Mr. Agarwal is making is conversing with the authorities, by the order, we also provide that he will be able to contact it will be faster.
Yes.
Yes.
Before that, you say, we also grant liberty to the learned counsel for the petitioner to interact, to telephonically interact with the superintendent of the transit camp Matia, so as to obtain information about the status of the travel arrangement of the petitioner.
Much obliged.
Somewhere in the order, we will also write the name of the petitioner so and so.
Published.
They released item 1 for hearing.
Yes. Mr. Sharma, Lordship. So Roshit has already based his submissions on the last date. On the last date, Mr. Rashid has already made his submissions.
Only one submission may have.
Yes,
That is regarding the dealing of the exhibits with the judgment.
pardon me.
Judgment stated one thing and annexer or exhibits which are not dealing with the judgment statement. So your
Not
lordship was
telling.
fixing, yes, that is the one of the factor. So on that point, your
This
lordship was
you did
asking.
not bring to our notice on the last date.
Yes.
Just show these documents.
My lord. So judgment is that is a page 40.
40. Then come to page 46. Page Milord, paragraph 12, exhibit F,
Page number,
page number 46.
pardon me,
46.
46.
My lord. What on that last occasion they were found?
Yes, page number 46. Yes,
Come, my lord. Exhibit F, exhibit G, and exhibit H are the admit card, school certificate, and mark sheet of the Board of Secondary Education School, has shown OP is the son of Sarab Ali Ahmed. That apart are that the total list of 1960 and 70 appears in the name of Asruddin Mia, Nurul Nisa,
46. Okay.
minor, and Stes Mother Milad Lemon Nisa.
In 46, you're reading paragraph 12.
Well,
Okay.
and kindly similar with the next Milad, original Milad exhibits.
Yes. Which page? Which was the page?
Page Milad 46, the last paragraph I am reading.
That we have read.
Hey, my lord.
Compare it with the documents.
My documents Milad, originally you Milad, only record is there. Yes.
We have the original record, but what do you want to show from this?
Actually, Milad, the exhibits which marked in the Milad record, those are not telling the judgment. Milad.
Yes, admit card is exhibit F according to the record.
My lord. And
Exhibit G
exhibit Q
is the school certificate, right?
my lord. And exhibit Q is the Milad,
Exhibit
Oh,
H is the
oh.
mark sheet, correct?
my lord.
What is wrong? It's not wrong, it's correct. I is the voter list of 1966, that is also correct.
Correct, my lord.
J is the voter list of 1970, that is also correct. Exhibit K is photo identity card, that is also correct.
My lord.
Exhibit L is the certified copy of registered sale deed, that is also correct. Mr. Rashid, you are not prepared.
I am probably Milad, I am mistaken.
You perhaps read something else. M is passport, everything is
Ma-
correct.
Then it may be after some time I will go to the record Milad. You can worship after some time. Hmm.
Yes. Yes, Mr. Sharma, you want the records?
Yes, Lord.
Take it.
What is reflecting here is that lordship, after 1917, lordship, all are changing lordship. Village name, as well as person's name, all are changing lordship.
After
1970.
Yes, 1970, Mondia to Behra. From Behra village to Mondia village. They have come. Yes, there is a thing.
But
After 19.
name is also নাম তো শিফট হয়ে গেছে না? If possible, lordship may take it up as first item tomorrow, lordship.
no, because difficulty is no, you tomorrow so many matters have
Yes,
already been ordered to be listed. You see, vaguely which I remember of the last occasion is that the in so far as the documents are concerned, the interpretation we leave it to you.
Yes.
The only part we remember is that this DW4 was the Gaonpura.
Oh.
His evidence is not
Considered.
it does not appear to be appropriate because it is not the Gaonpura who has signed it. Someone on behalf of Gaonpura has signed it in the letterpad of Gaonpura.
Yes, lordship.
So that is the only part. So what we require is the assessment of other documents which we did not apply our mind on that day.
Lordship.
And even if we applied, I don't remember it.
For the time being, lordship.
For the time being.
Oh, for the time.
Because you are also facing some difficulty in that hearing matters. It's now getting a big. The facts are so enormous.
Lord.
Not only the facts and the law cited is become so enormous. We are unable to retain anything else.
Lordship.
Just check it. The documents are not much. We did not have, check it. Just take it up.
Lord.
You will come to know.
Yes.
Take it up after 5 minutes.
Lord.
Just check it. You may not be able to take up any other matter. At 12, we think we'll start that APSC matters. You can give a scroll for this APSC matters at 12. আপনি হেইটা
এটা কত মিলি আপনি চাইলো মই আৰম্ভ কৰিছো If Gabra's evidence goes lordship, then nothing will remain lordship in this case. Case 39 lordship.
Apart from exhibit A and B,
Lord.
which are of 1960 and 1970, voter list of 1960, they are from a different village.
Yes, lordship.
They are from
Bhera.
Bhera,
Bhera.
but all other are from the same village, that is Mandya.
Mandya. Since 1989.
Yes.
Yes.
So therefore, it's a question of spelling, Sarbat and Sarab.
Sir.
Ali. The other fact is that the father of this Sarbat Ali or Sarab Ali are both Mansir everywhere.
Little bit different lordship.
Mansir,
One
Munsir.
is Munsir, another is Mansir.
That can be accepted as a wrong enumeration.
Yes.
Apparently, everything else matches. Apart from that, evidence of DW4.
Four. And lordship, another aspect is dear lordship, if we see page 61 lordship,
The only problem arises because the admit card, school transfer certificate and SEBA mark sheet, the tribunal says is not proved in accordance with law. Now this school transfer certificate, we understand, exhibit G, but this SEBA admit card and the SEBA mark sheet, that cannot be said to be not proved just because we did not call and the witness did not call. The proceeding did not call the SEBA. SEBA is not supposed to go to each and every, there's a presumption of the mark sheet issued by SEBA or admit card.
but here also lordship, name is different, father's name is different lordship.
May I submit that? My lord, what happened? I have, in fact, probably last time I argued this case, my lord. The main issue, my lord, your lordship will find the SEBA admit card is page 55, my lord.
Yes.
This is totally a different person, my lord. The father name is Sarab Ali Ahmed here. And the petitioner name is Azimuddin Ahmed. The the Saurabh Ali Ahmed. Who is this Saurabh Ali Ahmed? That is not confirmed because his other father's name and address is not found here. So unless this is exactly proof that this is the same person whose name was there in 1970 and 66, we cannot say because the name there is Saurabh Ali Malak. Sarbat Ali. And why I probably argued this one thing, my lord, if your lordship may kindly see 1989 voter list.
1989.
Yes, and 1970, because
Yes, 1970 is at page 59.
yes, page 59, kindly see 59, 60, man. This is at Behera village. Who are the my lord, voters here in 1970? The Megu Mia, son of Mansur, Kitab Ali, son of Mansur, Hassan Ali, and Hassan Ali, Hassan Ali, son of Mansur, and Sarbat Ali, son of Mansur. They are claiming that this Sarbat Ali is the father of the petition. Now, in fact, in Sirazul Haq, Supreme Court has said the spelling mistake in one word, it can be accepted. But condition is that the older other persons whose name were in the voter list, they should continue the next also. If the other persons are similar in the next voter list, then the spelling mistake in that, that may be excused. That can be ignored. Now, if we say this is the same person as page 62, with the voter list of 1989, not a single person at there here in 1989 it is Saurabh Ali, Here it is Saurabh Ali. The village is different. Here is the Saurabh Ali, not Sarbat. One thing is that we could accept it, that it may be a spelling mistake or some we could ignore it. If the other voters of 1970, any one of the 1970 voter list will exist in this voter list. Not a single from the the 60 and 62 page, only similarities. One Saurabh Ali, in fact, it was Sarbat in the earlier occasion, and it was Mansur. Here it is Mansur. The age is in fact age is also not telling because if 1970 this yes age will be almost 1-2 years different, but the father's the name is different, and other voters are not there in the voter list of 1989 at page 62. Had there been any other voter from this 1970, we could accept there may be a spelling mistake. So it can be a different person also. We cannot say it. That has to be proved by them that it is the same. They are the same person. It is their duty to prove that he is the same person because the other voters are not there in 1989. That is the first issue, Now, in 1989, it is Saurabh Ali, son of Mansur. Now, to prove that he is the father, this Saurabh Ali is the father. He has produced the the admit card. Admit card is admit card is 55. Page 55. Here it is Saurabh Ali Ahmed. Who is Saurabh Ali Ahmed? That is not described here. Saurabh Ali Ahmed, son of so and so, that is not there. The Gaubura here, my lord, the second certificate, second document is Gaubura to link himself with the. Now he is trying to link with Sarab Ali, my lord, not with Sarab Ali Ahmed, Majumdar. Majumdar.
Hmm?
Sarab Ali Ahmed. The admit says his son of Azimuddin is son of Sarab Ali Ahmed. Now he is trying to live with Sarbat Ali of 1970, my lord.
You see, so far as I understand, subject to concurrence by my sister, the petitioner has a good case, but he was in the wrong hand.
I don't know.
No, come to page 63. You have seen the admit card. Now come to page 63.
$63.
CLD is between Mustafa Anwara Begum. This is the mother. Mother came and deposed. Wife of Sarbat Ali Ahmed. Therefore, Sarbat and Sarab is interchangeably used.
Yes.
Sarbat Ali Ahmed again comes. And the village is Bhera. 1966 and 70 water is at Bhera.
That means like there is a shifting, that part is the main all of the issue. 71 he was there after
But,
71.
but you've not been able to show anything. Evidence is not led in that manner. The petitioner will never know how to lead evidence, but the lawyer also does not know anything. Because once this is not really proved, then there is a gap in the evidence.
And mother also deposed to the yeah, lost it. I'll try to. 628. Mother.
That's why I said, you see, whenever we start reading, we find that the case was not well presented.
Another
It is
issue is there, my lord. Is this Anwara Begum, wife of Sarbat Ali Ahmed, who was the wife of Sarab Ali of 1970. Sarbat Ali of 1970. But in 1970, in
No,
Putar
the error which was made, come to page 23. That is the big error. Just like people who take who know how to hold a steering wheel cannot become good driver. Same thing here. You see, first line, Anwara Begum's son, wife of late Sarab Ali Ahmed.
Yes. As it was 9 years.
Correct. Sarab Ali Ahmed, she goes and says. And then para 2, she contradicts herself.
Yes. I was born.
I was born and brought up at village Mandiagaon, and after 10 major, I was given marriage to Sarbat Ali. Now there lies the difficulty.
Yes. And that, my lord, that again, that caused problem because in 1970 Putar list, the petition, the father, this Anwara is not along with this Sarab Ali. In 1970 Putar list, my lord, this Anwara should have been there in the Putar list with Sarbat Ali if she is the wife of that person.
No, should have is something we
No,
want
it is
to-
not there, my lord.
It's
Documentary
not there,
evidence.
but
is there, yeah.
that's all. It's
As
not
a
there.
documentary evidence, that could have been there. Had then been there, my lord, she could have said, yes, I'm the same person. That could have been it. Because
Before 1970 Miller, there is another portal which is given from the side of her father Miller. That is annexed. But I have not annexed here, that is not relevant here, Miller.
No, father is not relevant.
Yes,
but it's not.
her father Miller.
No,
But
father
my
is not
father, that is
relevant.
very relevant, Miller. And her mother statement is there. And she has
No,
stated that
she's
she is my son.
69 years in 19, my lord, 2000. This is 28 2018. 2018-69, my lord.
But
And for the fault of my lord advocate or my lord misleading advocate, my lord, your lordship, the petitioner of your lordship is, I am claiming my lord he is genuine. But what happened, my lord, for the fault of advocate or misleading the my lord some place.
but you see, this it's not your pleaded case. In this writ petition, you are not making any allegations against the lawyer and said that you are not.
I cannot try. And my lord,
But
then
then-
it will go back and he will again, I am to send notice to him and he will come near, no, these are documents he has given.
Then
Then
you can't help
automatically he
it
will be
because
released.
it just doesn't match.
Yes, that is not the something here. He has got it right.
The evidence just does not match.
And here in the mirror, your lordship has seen only the difference between the name. Sarabotali, etc. my lord. And mother versus name, my lord, but that is after cut date, cut of date, my lord. That is my lord 25, yes, 15/12/1971. It ought to have been before 25/3/1971.
Even then, my lord.
But name is there.
It's just not matching.
Now, if your lordship consider my lord Sarabotali in my
No,
affidavit.
not even that. When your mother gives evidence, it contradicts your evidence. The mother, come to page 26. In paragraph 11, she says four sons, 2 daughters.
My lord. 4 sons.
4 sons and 2 daughters. That's not your pleaded case. In your written statement, you don't say about that. Now you contradict your mother by come to page 19.
No, yes.
In page 19, you say my mother's name is Anwar Begum, my brother's name is Nazim and Sophie Ahmed. Sister name is Jahanara. So therefore, it's a mismatch in the family. You don't know how many brothers and sisters you have. Your mother does not know how many.
Children here. More or less.
Then comes the name difference. And therefore,
Yes, one thing, right? Sarabotali, Sarabali, and Sarabali Ahmed. They are the same and one person. That is husband of the petitioner. Paragraph 13.
because your mother in her evidence conveniently makes the change in the name of the husband along with the document. In the narration, she says she is wife of so and so. But with documents, she says that she is the wife of Sarwat Ali. Sometimes she says sometimes Sarab Ali Ahmed. So with convenience, she
Both the
changes.
are same and one person.
With convenience, she changes the name. You have a very good. If you could have demonstrated written well, you had a good case. Your wife is also given. Your mother has also given a reason for shifting, but you've not been able to connect it. She exhibits the land documents
Also,
and says that the
other mistake
land is at village Mandia. But how the shifting took place, you don't say anything. Where you are currently staying, you are not saying that. So therefore, it's only a certified copy of document which does not prove the existence.
Actually, what happened, Gaura Milord? Gaura, to my personal knowledge, Milord, that person was ill. So his son was doing duties. So he has issued certificate. But these are not mentioned here, Milord. He was ill or he was in charge.
In English, we have a good name for that. It's called tout.
But he is son, not Tau.
Supposing a man is ill, supposing this police station, the officer in charge is ill. His brother cannot come and sit and work as OC.
Actually, name should be changed there. In charge or his name should be Kasmira Lloyd Das.
Activate assessment.
Yes, no. Kilo. That is what. Government working there, that will be say liquid road.
Yes, Mr. Rashid, you were saying that you will try to show us the discrepancy in the documents.
No, will not actually, either I am mistaken, will not, probably, but
No, so far as the exhibits are concerned, we find it consistent.
I have actually,
It's consistent. I have checked it out.
maybe some other case for him, but I was checking, we found serially, A, B, C, D, E, F, G, H, I, J, K, L, M, N.
No, sorry, Mr. Rashid, we'll have to dismiss your repetition. But Mr. Payang,
My lord.
for this SEBA's admit and this SEBA mark sheet, we'll have to say that the rejection of these two exhibits were not improper.
That is true, my lord.
Because if we say otherwise, then in all cases, all the headmasters and principals and then SEBA, HSLC, AHSLC, and then university people, they'll be running from here to there to give evidence.
But it will go to 1971.
Only point, my lord, is what I submitted with, my lord, from mark sheets and admit, the description of father cannot be, my lord, from.
No, that's okay, but
Yes.
it was rejected
Yes,
on the ground that
Yes, it was,
the concerned officials did not come. This
Yes.
part will have to
yes, that part probably, my lord, that
say
part
it is incorrect.
And admitted mark sheet, Milord, I have found, Milord, we have also said those documents, Milord, but nowhere it written in admitted mark sheet, Milord, name of the father or mother. But nowadays, Milord, presently, Milord, I have seen, Milord, recently, Milord, the name of father and mother written, but address is not there.
No, earlier it was
Earlier only father's name.
only
was there.
father's name was there,
Yes.
but the
Everyone
government thinks fit to give
Now, Milord,
both the
now
description.
father's name first, now mother's name first, then father name, then he's candidate, Milord.
It's good, not bad.
Yes, Milord, that is good, but earlier that was the system. And probably, Milord, we are here, everyone is not on that category.
Had
With
there
only
been
with the
the
father's
name,
name.
had there been name it consistent with 1970 voter list, my lord, there was no problem. But the name is different. That is the issue.
Mother is saying time and again, Sharbodali is the same around person. I have married with same Milord. Same.
What I project tried to manage say last then. My lord, the 1970, the mother name is not there in the voter list because she was 21 years in 1970. And it is from the document what she has submitted, she got married prior to 1970, my lord. 71.
Where is
She
written
sold-
that she was married in 1970?
No,
There is
she-
no mention. How he is saying when I before
No, because the tribunal gave a finding. It calculated the age and then said that the petitioner was born in 1966. So therefore, she has to be married before.
Yes.
Not born 1960, but she should be married before 21 years.
If she is,
Many persons
It's
they are
not a
married
question
in
of
36
years. It's not a question of
It is
age.
government rule in before 18, if someone is married below,
No,
then police
they are
will
not.
come.
They are
But
not
some
questioning.
36 years, they are not.
No,
married
you are
below.
making a wrong argument.
No.
He's not saying about the age of the marriageable age of the mother.
There is not. Yes.
He says that when your mother got married, when you were born in 1966 or 67, your mother would have married earlier, but the name of your mother does not appear in the voter list of 1966. That's what he's saying. He's only elaborating he's merely elaborating what is already there in the
At the relevant date, my
opinion.
lord, I may not, mother may not be married with my father.
Mother?
May not be married at the time.
70 voter list also at least. My lord, what my son is not even 66, in 70
We
also.
don't know. That's not the case. That the mother, unmarried mother, gave birth to the petitioner. That's not your
I
case.
do not think so.
No, you are now saying that she may not be married.
No, at the relevant, my relevant saying, my lord, 66. So, and immediately after marriage, my lord, no one's, our name is not appeared in the voter list, my lord, your lordship. Some time is required.
If the petitioner was born in 1966, in fact, the mother would have been married earlier also because he has, in his written statement, says his elder sister, Jahanara Begum, is also there.
Let them born.
You see. Okay, ask me. Certificate again. Hey, but you go take the request. The certificate is the proper care. Mr. A. Rashid, Learned Counsel for the petitioner. Also, all the respondents are there, Mr. Ahmed on behalf of AIM, and Mr. B. Sharma, CCC. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 40, 15/2/2020, passed by so and so and so and so, reference IMDT case number so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream.
Next, please.
Next, upon receipt of note, the records reveal that on receipt of notice of the proceedings, the petitioner entered appearance before the learned tribunal and submitted his written statement. Wherein it was stated that the petitioner was born and brought up at village Mandia Gaon, Mandia, Mandia Gaon, in the district of Bapta. The name of his grandparents were Monsur, Monsur, and Kadban, Kadbn, Kadban Nessa. And the name of his parents is Sarbat, Sarbat, Sarbat Ali, alias Sarab Ali, Sarab, Sarab Ali, alias Sarab Ali Ahmed, and Anwara Begum. It is projected that the that his brothers are Nazim Uddin, Nazim, Nazim, next word Uddin, Ahmed, comma, Sophie, SOFI, Sophie, next word Uddin, Ahmed,
May I read me lot some for them?
pardon me?
I may read me lot for some.
Ah, yes, yes, yes.
But first, my
So,
colleague will tell.
Nazim, Sophie Uddin Ahmed. And his sister is Jahanara Begum. Jahanara, Jahanara Begum. And he is referred to the names which find entry in the voter list of 1966, 1970, 1989, 1997, 2010. Most of it is also claimed that the grandfather of the petitioner expired before the year 1966. And that initially the names of the projected father of the petitioner appeared in the voter list of 1966 and 1970 at village Bhera, BHERA. And after 1970, the parental family of the petitioner shifted residence from village Bhera, BHERA, TO2, village Mandia, Gaon. So accordingly, it is not accordingly, it is further projected that Sarbat Ali, Sarab Ali, Sarab Ali Ahmed, and Sarab is the name of the father of the petitioner, and therefore said 4 persons are same and 1 person. So accordingly, it is claimed that the petitioner is a citizen of India, and therefore the proceedings against him may be dismissed. Full stop. Next, by filing his evidence on affidavit, the petitioner has reiterated the statements made in the written statement, and in support of his defense, the petitioner has exhibited at page 18 to 20, exhibit A to J. Just no, take it from here. It will be better. Take the exhibits from page 42. Exhibit A to Q. Make it till J, huh? Not Q, till J. From page, this, from page 42. Full stop. Next para, the petitioner is also examined his mother, or his projected mother, Anwara Begum, ANOWARA, Anwara Begum, as DW2. Who is stated in paragraph 11 of evidence on affidavit that she had 4 sons and 2 daughters, namely Nazim and Zedam, next word Uddin, Ahmed, Azim, next word Uddin, Ahmed. Third is Saiful, SAIFUL, Saiful Islam. Next, Sophie, SOFI, next word Uddin, Ahmed, Jahanara Begum, and Saliha Begum. And in paragraph 12 of her evidence on affidavit, the DW2 states that her husband had 3 brothers, namely Meghu Mia, MEGHU, Mia, next word is Kitab Ali, KITAB, Kitab Ali, and Hassan Ali, ASAN, Hassan Ali, and 2 sisters. And she had also stated that she has land documents in respect of land at village Mandia, MANDIA, Mandia Gaon. Next, the petitioners also examined one Nazimuddin Ahmed, the projected brother of the petitioner, is DW3. Was stated that he was born and brought up at village Mandia Gaon. And the petitioner was also born and brought up at same village. He has reiterated that the name of his grandfather was Mansoor and grandmother was Kadbhar Nessa. And the father's name is Sarbat Ali, alias Sarab Ali, alias Sarab Ali Ahmed. Her mother's name is Anwara Begum and elder sister name is Jahanara Begum. and he has re-exhibited the documents which were already exhibited by the petitioner's exhibit A to G, exhibit A to exhibit G respectively. First of the BW 3 has also reiterated that he has three uncles, namely Megumia, Kitab Ali, and Hassan Ali. Full stop. Full stop. While in paragraph 2, the petitioners disclose the name of only his sister Jahanara Begum. In paragraph 8, the petitioner, the DW3 has disclosed the name of one brother, Sofi Uddin Ahmed, and sister Jahanara Begum. But in paragraph 12 of his affidavit on evidence on affidavit, DW3 states that he has three brothers, namely Azimuddin Ahmed, Safiul Islam, SAIFUL, Saiful Islam, and Sofi Uddin Ahmed, and two sisters, namely Jahanara Begum and Saleha Begum. However, in his cross-examination, the DW3 states that they are four brothers and two sisters. One Nipul Das, NIPUL, Nipul Das, was working as head Gangura of Mondia, MONDIA, Mondia Gaon, and Mondia Pathar. Was examined as DW4. Say DW3. Please add. In course of cross-examination, in course of examination of the oral examination of the DW3 before the Lionel Tribunal, he has exhibited copy of his passport as exhibit M, service identity card, exhibit N, admit card within bracket exhibit O, and voter ID, electoral photo identity card within bracket exhibit P. Now this DW4. First one. In course of his examination, the petitioner, the DW4 has stated that he had issued a certificate in favor of the petitioner, which was issued on a printed certificate of Sri Lohit Das, his father, by entering some contents on it. He also admitted that the contents were not entered by him in the certificate, and that no date was mentioned in this signature on the certificate. He also admits that he had issued the certificate without any verification, and mentioned that Sarab Ali and Sarvat Ali is one and same person. The said certificate was exhibited as Exhibit Q, with his signature as Exhibit Q by 1. And he did not maintain any record of who received this copy of certificate, within bracket Exhibit Q from him. Next paragraph. Okay, we'll try to complete the dictation in chambers. Otherwise, we'll be not be able to do anything else. Mr. Rashid, sorry, Ms. Begum. If for some reason we cannot complete our dictation today, we'll make it, we'll reserve it for judgment.
Yes.
If you can dictate it, then we'll pass orders today.
Yes.
Please check with the courtmaster tomorrow morning.
I'm really deeply obliged for that.
It's a part of the judicial process. You made a prayer, we allowed it.
No, Lordship. Well, Lordship, actually, in fairness, not all prayers are allowed. Because one side always loses a prayer, Lordship. So I joke and say, Lordship, ultimately, one side wins, one side loses. So always one side leaves satisfied, one side leaves unhappy. Such is the
And
task.
the very good part of it is that while going out only, they say, judge does not understand anything.
Lordship, फिर मैं मजाक में कहता हूँ, I've not met a single guilty man in my life who has said that I'm guilty. So, Lordship, I was on the principal, Lordship, yesterday. I had completed probationers and I'm on part 2, Lordship. So, if Lordship may just keep the second compilation, which has Krishna Yadav, and the judgment I'm today reading is State of Madhya Pradesh versus Shyama Pardi. And Lordship, I have now started going to the next principle. They'll get intertwined, but all the queries that will keep flowing, Lordship, will get answered from all the judgments. And in the end, if I need to satisfy Lordship on anything additional, I'm there. So, Lordship, where the appointment has been secured.
I'll just address the students, student interns sitting behind. We'll just tell you that this is one of the cases where the service of, no, not required. The service of ACS officers, APS officers were all discontinued by the state. A challenge was made, which was rejected by the learned single judge, and therefore this intra-court appeal, where the officers whose services were terminated are before us, and now for the state, Senior Counsel Mr. Kohli is addressing us to sustain the orders passed by the government to terminate the services. So that's for your understanding so that you can follow it now. Yes.
And Lordship, on this matter, so many principles of law are covered. We have dealt with probation yesterday. Today we are talking of illegal appointments. Writ jurisdiction and its scope will follow, Lordship. Article 311 will come. So it's a very good learning, and I'm very kind of Lordship to give them a sense. So if they hear the judgments, it will be a good learning experience. So Lordship, I have started on the proposition when the appointment has been secured through illegal means or the appointee was not qualified at the time of appointment, such appointment is void ab initio, and consequently no violation of principles of natural justice can be claimed. I read yesterday 1994 4 SCC 165 Krishna Yadav. Today I'm shifting to 1996 7 SCC 118 State of Madhya Pradesh versus Shyama Pardi. Lordship, now, Lordship, the difference we'll find is Krishna Yadav led to the termination of the whole system, whole selection. Shyama Pardi is an individual case. So, between the judgments, we will see both. And Lordship, principles of natural justice argument is covered here also. But Lordship, these appeals by special leave arise by the order of the Administrative Tribunal, Jabalpur, the MP Public Health and Family Welfare Department. This was a class 3 rules, Lordship, made under Proviso 309, prescribed qualification for appointment of auxiliary nurse cum midwife. So this is for an auxiliary nurse cum midwife. And these are the qualifications 10+2 with physics, chemistry, biology. Now, Lordship may mark, admittedly, the respondents had not possessed the qualification. It would be seen that the district medical officer therefore wrongly selected the respondents and sent them to training. Then one sentence below, Lordship. The respondents were served with notice in 1994 January, intimating that their selection for training was illegal and their services would be terminated with effect from February 1994. The respondents challenged the cancellation of the appointment. Para 4. The tribunal in the impugned order had held that the respondents, having been selected and undergone the training. So the argument of training comes again. I have undergone the training after selection. And the competent authority having duly appointed them, cancellation of their appointment without any opportunity is violative of the principles of natural justice, and it accordingly set aside the order and directed reinstatement with consequential benefits. Para 5. It is now an admitted fact across the bar that the respondents had not possessed the requisite qualification, namely 10+2 with physics, chemistry, biology as subjects. The rules specifically provide that the qualification as a condition for appointment to the post of A&M. Since prescribed qualifications had not been satisfied, the initial selection to undergo training is per se illegal. Not irregular, Lordship, illegal. Later appointments thereof are in violation of the statutory rules. The tribunal therefore was not right in directing the reinstatement of the respondents. The question of violation of principles of natural justice does not arise. Why? Because the appointment is illegal. The ratio of Shravan Kumar Jha, and then Lordship, that is going just on training. So the short point is, Lordship, if your initial appointment is illegal, the argument of principles of natural justice has been rejected by the Honorable Supreme Court. Basically, the appointment which is illegal is a void ab initio appointment. Hence, no right can be claimed under the principles of natural justice or the statutory rules. And Lordship, in this context, the argument becomes important. If I can call it, Lordship, the Lakshman Rekha. The entry point is the Lakshman Rekha. In cricket parlance, Lordship, are you off the field or on the field? The minute you cross that boundary, you are on the field. The appointment is that boundary, Lordship. And the question here comes that their entry not being bona fide or being driven by a taint, that does not mean they can start claiming rights. What would apply to a bona fide entry into the service? Lordship, next judgment is O Chakradhar. O Chakradhar Lordship is 2002, 3 SCC 146. Union of India versus O Chakradhar Lordship. Justice Patnaik, GB Patnaik and Brajesh Kumar. Justice Brajesh Kumar has authored it. So now Lordship from 94 we have come to 2002. I will Lordship race through the first few paragraphs just to give Lordship the facts and not read it. Now the important thing Lordship is Krishna Yadav is also relied and reiterated in this judgment. So Lordship, basically they were typists and there was a certain requirement which was not met, Lordship. They had to undergo a typewriting test. Now Lordship, for a typist, that is the most important test. And it's a class 3 post. It's not even, Lordship, such a high post, but this is class 3 post. Let's see what the court says. So that facts are covered from para 2, Lordship, to the next page. Lordship may come to placentum B and C. In para 3, Lordship, right at the top of the page, I wish to show the argument, Lordship. So Lordship, this was after, at the top of the page, Lordship may mark, taking into account the report of CBI. So again, there is a police investigation or a CBI. First sentence on page 19, on the top of the page. 149, that would be, of the internal page of the judgment.
Yes.
And then Lordship, the next paragraph, the first sentence says they were terminated in 1999 after 3 years of service. So these are typists. The initial entry is questioned on the ground that the requirement of typewriting exam was not conducted. It is questioned, there is a police report or there is a CBI. They are terminated after 3 years. Now, Lordship, between placentum B and C, the other ground of challenge, there is a sentence, Lordship. It's approximately the 9th sentence, Lordship, from the top. The other ground of challenge is that a proper show cause notice should have been individually issued to each selectee. So this is a group individually issued to each selectee so as to enable him to submit his proper explanation in respect of the allegations of irregularities. In the absence of such notice, the termination order is bad being in violations of principle of natural justice. So para 4. The Central Administrative Tribunal, while deciding the case, held that merely saying that serious irregularities were committed in conducting the selection of the typing test was not held. Such general allegations could not be enough to take a decision to cancel the whole selection. It also observed that the show cause notice which was issued is silent about any irregularity in the selection which can be attributed to the applicant. Therefore, the show cause notice was inadequate and incomplete. It has further been observed that the report of the CBI, only Lordship, the CBI, cannot be the only refuge for the cancellation of the selection, but its contents should be brought to the knowledge of the applicant in a concise form to enable him to give a proper reply, but it was not done by the administration. Thus, in absence of proper notice and opportunity to the candidate, the order of termination of the applicant stands vitiated. The tribunal observed that the CBI report was not placed before it. With the above findings, it was set aside. So, Lordship, everything that could be argued was considered. The tribunal ruled in their favor. And Lordship, this is also a case where there is a show cause notice, no inquiry. So this is important. These facts are a little different. Now, Lordships, let's see the arguments that come in the writ jurisdiction, para 5. The writ preferred by the appellant against the order of the Central Administrative Tribunal was dismissed as indicated earlier. The judgment of the High Court in the writ petition is also mainly based on the ground of violation of principles of natural justice, and the notice which was given was vague and amounted to no notice at all. So, Lordship, they succeed at the Honorable CAT, the Learned Tribunal. They succeed before the writ jurisdiction, now before the Supreme Court, what is argued by the government, the union. Shri Mukul Rohatgi, Learned Additional Solicitor General, appearing on behalf of the appellants, has placed reliance on the decision of Krishna Yadav versus State of Haryana. And on the basis of the same, it has been vehemently urged that in case where irregularity committed in the process of selection is all pervasive, vitiating the whole selection, In that event, it would not be required that each selectee be served with individual show cause notices. In such circumstances, it is open to cancel the whole selection. So Krishan Yadav's whole ratio, Lordship. Now, Lordship, para 7. The Honorable Court, the Supreme Court says, okay, Lordship may just mark in the middle of the page, in the above para, between around presentum B, the argument of Article 311's violation is also considered. It's put forth before the Honorable Supreme Court. Now, Lordship, the ratio starts. And the argument being, if a show cause notice is issued, an inquiry must be done. Now, see, let's see what's from para 7 starts. Before we proceed further, it would be appropriate to peruse the decisions relied upon by the parties. In the case of Krishan Yadav, the allegations of favoritism and arbitrariness in holding the selection to the post of taxation inspectors by the subordinate selection board was held. Lordship may come below placentum E. In such circumstances, it was held that the entire selection was vitiated even in respect of those who had already been appointed and had been working for a few years. Please mark, it was further observed that individual cases of innocence have no relevance in these circumstances. So far as the respondent is concerned, reliance has been placed on the decision of Kashinath Dikshita versus Union of India on the proposition that a case where reasonable opportunity of hearing is denied to a delinquent, it vitiates the inquiry and renders the order of punishment invalid. There cannot be any doubt about the proposition of law as propounded in the above noted case. Reasonable and adequate opportunity of hearing has always to be provided to a delinquent officer against whom disciplinary proceedings have been initiated by the department. Please mark, Lordship, the next sentence is critical. The case, however, pertains to an inquiry against an individual officer based on allegations of misconduct on his part. Let's turn the page, Lordship, to para 8. In our view, the nature and extent of illegalities and irregularities committed in conducting a selection will have to be scrutinized in each case so as to come to a conclusion about future course of action to be adopted in the matter. If the mischief is so widespread and all-pervasive, affecting the result, so as to make it difficult to pick out the persons who have been unlawfully benefited or wrongly deprived of their selection, in such case, it will neither be possible nor necessary to issue individual show cause notices to each selectee. The only way out would be to cancel the whole selection. Motive behind the irregularities committed also has its relevance. Then, Lordship, they consider the CBI report, Lordship. At the bottom of the page, Lordship, at para 10, it's only, Lordship, I'm speaking about the irregularities. Answer sheets did not bear the signature of the supervisor, very similar to ours, Lordship. Placentum H. Just Lordship may mark near placentum H. About 100 answer sheets did not bear the signature of supervisor. Then difference in handwriting, Lordship. Some of the allegations are similar. Turn the page, Lordship. That is the difference of handwritings. All that, Lordship, is mentioned. Para 11 says, there is reliance in the first sentence. It is mentioned in the report being the CBI report. So they consider that. Come to para 12, Lordship. As per the report of the CBI, the whole selection smacks of malafides and arbitrariness, which means there is a total reliance on the investigation of the agency, in this case being the CBI. In our case, there is a detailed and thorough investigation by the police. All norms are said to have been violated with impunity at each state, namely right from the stage of entertaining applications with answer sheets while in the custody of the chairman, then holding the typing test, etc. Very similar, Lordship. Then 3 sentences below, Lordship, above placentum G. The illegality and irregularity are so intermixed with the whole process of selection that it becomes impossible to sort out the right from wrong or vice versa. The result of such a selection cannot be relied or acted upon. Please mark, Lordship. It is not a case where a question of misconduct on the part of a candidate is to be gone into, but a case where those who conducted the selection have rendered it wholly unacceptable. Guilt of those who have been selected is not the question under consideration, but the question is, could such selection be acted upon in the matter of public employment? That is the weighing and important factor on the mind of the court always, Lordship. can a person who has a severe allegation on him or her, can they be allowed to be occupying public office related to the arguments of public trust, etc.? And in this case, Lordship, we are not even talking about a confirmed employee. We are talking about a probationer. We are therefore of the view that it is not one of those cases where it may have been possible to issue an individual notice of misconduct to each selectee and seek his explanation. Then Lordship may come to the third last sentence above placetum B. The decision in the case of Krishan Yadav applies to the facts in the present case. The Railway Board's decision to cancel the selection cannot be faulted with. The appeal therefore deserves to be allowed. And Lordship, para 14, the copy of the CBI report has been placed on record. The administration shall do well in bringing action pursuing the matter in light of the report of the CBI. Not only they cancel, the Honorable Court basically leans in favor of action being taken on the basis of the police investigation, or in this case, the CBI. Next, Lordship.
But then again, here the same thing has come, which we spoke of yesterday.
Lordship.
Here, the last paragraph, this page 22.
Yes, Lordship.
We are therefore of the view that it is one of those cases where it may have been possible to issue the individual notice of misconduct. So therefore, these are only a few people who were
Right. So therefore, Lordship, even if that argument be taken, ultimately this will get answered. I'm just showing the continuation of law. A few more judgments, Lordship, two things will get clear. That in a large scale mass problem where it is difficult to segregate the tainted and the untainted, or segregate, as the court uses a word, the grain from the chaff, you cancel the whole exam. We will see, Lordship, the settled law is that if you can do that exercise as our state has done, Lordship, then you don't need to cancel the whole exam. The second, Lordship, is we will clearly show judgments that say no notice is required. So every case, some facts difference are there, but I'm basically building on the proposition of law. Lordship may be pleased to come to the next judgment, which is Ashok Kumar Sonkar versus Union of India. Again, two bench Lordship of the Honorable Supreme Court, 2007, 4 SCC 54. Lordship, para 3. I will show only a few paragraphs in this, Lordship. Broadly may come to para 1, Lordship. I'll just point out what is the issue. It's very interesting, Lordship. This was a single case. Now we are on a completely individual case. And this was an appointment in the Banaras Hindu University, Lordship, for filling up the post of a lecturer in Tridosh Vigyan. So it's a post which is there. Now, Lordship may just come in the middle of the page. The qualifications, essential qualifications, number 2 is MD in Sharir Kriya. Right, Lordship? Now, para 3. So, therefore, the requirement, what is the case here is very interesting, Lordship. He did not possess the required essential criteria qualification on the date of the appointment. He was undergoing that training. He gets it subsequently. And what does the court hold in that? Para 3. The appellant applied for the post on 3595. As on that day, he had not completed his MD in Sharir Kriya. With his application, he enclosed a certificate issued by the professor and head of the department of the Basic Principles Institute of Medical Sciences, which basically says he's a bona fide student, he's studying. Para 4. He passed the examination on so-and-so date, October 95. He was allowed to appear before the selection committee despite the fact that he did not hold the requisite qualification till the date of filing such application. He was, however, selected and offered appointment. He joined the post. In the meanwhile, respondent 4 filed a writ petition before the Allahabad High Court. The High Court, by reason of an order dated 17th of February 98, dismissed the said writ petition on the premise that he had an alternative remedy, which is respondent 4 thereafter moved the President of India in his capacity as visitor of the said university. The visitor was of the opinion that the selection process was illegal. The selection proceeding therefore was set aside. Now, Lordship may come to para 26. Now, Lordship, Here, the whole argument of principles of natural justice has been dealt in some detail in this judgment. So, Lordship, just before I read those paras, the Honorable Court on principles of natural justice has also crafted exceptions. The old view was, Lordship, that there had to be in every case following the principles of natural justice, which means giving due opportunity to a person on whom any allegation came. So it was assumed that you would have to comply with the principles of natural justice. Over the decades, Lordship, the law has moderated and changed to the extent that now there are exceptions. And Lordship, they have to look at the facts of the case and the outcome of the process. Lordship, may please mark this. It is not just the facts of the case, but it is the outcome of adhering to principles of natural justice. In that, Lordship, the courts have crafted the use of the term empty formality or useless formality. More often than not, the word empty formality is used, though in this judgment, the term useless formality is used, but that is how the doctrine of empty formality has come. Essentially, Lordship, being that if the outcome is expected to be the same, you can't take the rigid stand that it must be complied with by giving an opportunity to the alleged delinquent. So this is in this judgment that is dealt with in detail. Para 26, Lordship. This brings us to the question as to whether the principles of natural justice were required to be complied with. There cannot be any doubt whatsoever that the odi alteram partem is one of the most basic pillars of natural justice, which means no one should be condemned unheard. However, wherever possible, the principle of natural justice should be followed. Wherever possible. Ordinarily, in a case of this nature, the same should be complied with. Then para 27. It is also, however, well settled and it cannot be put in any straight-jacket formula. It may not be applied in a given case unless a prejudice is shown. It is not necessary where it would be a futile exercise. Now let's see, Lordship, para 28. A court of law does not insist on compliance with useless formality. Is Lordship with me? Thank you. A court of law does not insist on compliance with useless formality. It will not issue any such direction where the result would remain the same, in view of the fact situation prevailing or in terms of the legal consequences, fact or consequences. Furthermore, in this case, the selection of the appellant was illegal. He was not qualified on the cutoff date. Being ineligible to be considered for appointment, it would have been a futile exercise to give him an opportunity of being heard. So, Lordship, if the appointment per se is under a doubt and a major question and is illegal per se, it is void ab initio. The court is not going to indulge in giving an opportunity for something which would be considered a futile exercise. Let's see further, Lordship. They rely on a judgment. This is also a very famous judgment. I was to produce it, but I found the paragraph here, so we thought we'll just show that one paragraph here. Para 29. In Aligarh Muslim University versus Mansoor Ali Khan, the law is stated in the following terms. The useless formality theory, it must be noted, is an exception. Apart from the class of cases of admitted or undisputable facts leading only to one conclusion referred to above, there has been considerable debate on the application of that theory in other cases. So, Lordship, just to pause, this will give a very nice paragraph about what has been the evolution of it and what are the different schools. In one paragraph. And second, Lordship, is that if only one conclusion is possible, and based on the police report or the CBI in other cases, if that conclusion is so apparent in the investigation, therefore, Lordship, our case becomes that they needn't have been complied with and they were only probationers. Let's read, Lordship. The divergent views expressed in this regard or to this theory have been elaborately considered by this court in MC Mehta referred to above. The court surveyed the views expressed in various judgments in England by Lord Reed, Lord Wilberforce, Lord Wolfe, Lord Bingham, Meggery Justice and Justice Stockton. In various cases, and also the views expressed by reading writers like Professors Garner, Craig, DeSmith, Wade, D.H. Clark, etc. Some of them have said that the orders passed in violation must always be quashed, for otherwise the court will be prejudging the issue. Others have said that there is no such absolute rule and prejudice must be shown. Prejudice by the person who claims it. Yet some others have applied via media rules. We do not think it necessary in this case to go deeper into the issues. In the ultimate analysis, it would depend on the facts of a case. The Lordship had spoken about common law. Even in England, there is, in terms of English law, there is no fixed doctrine that there must always be compliance. That is the traditional view. And now the exception has become the rule. In the sense, you will look at a case, if it is gross requirement, prejudice is shown, and it will lead to another outcome, then you must consider it. So, Lordship, in 311 also, there is an exception. So, even under the Constitution, there is an exception and it's crafted in three situations. Lordship, in the next para, in Karnataka, SRTC versus SG Koturappa, the court held, the question as to what extent principles of natural justice are required to be complied with would depend upon the fact of situation obtaining in each case. The principles of natural justice cannot be applied in vacuum. They cannot be put in a straight-jacket formula. The principles of natural justice are furthermore not required to be complied with when it will lead to an empty formality. So this is the word used more often, Lordship. When what is needed for the employer in the case of this nature is to apply the objective criteria, please mark, Lordship, apply the objective criteria for arriving at the subjective satisfaction. Now, Lordship, I ask myself, the investigation is the objective criteria which presents before the government. What are the grave allegations against these people or appellants in terms of how they secured their appointment to public office? How? That is the objective criteria. The decision of the government, and we've dealt with it in an earlier judgment, which was Justice Gawai and Justice Bobde's judgment, Justice Suryakant's judgment, that after all, there will be a subjective aspect to it, and that subjective aspect has to be applied by the government. May I finish this judgment, Lordship, or would Lordship like to rise?
No, we'll have to rise because there's a meeting at 1:15.
Oh, of course, Lordship. Grateful, Lordship. I'll continue from this point.
See, why I referred to that, about the English law is that having read Subramaniam Swami's judgment, there is a reference to the common law and says it's an integral part of the Indian law. Now, to know that on that particular subject, I started reading Halsbury Laws of England. I think it's volume 2 or volume 3. And despite my lot of effort to try to read that book, there is so many footnotes and notes here and there that by the time you read all the notes and come back to the topic, you're already finished. So there is it's such a clumsy. My impression is that it was so clumsy that for a new reader, it was not an entertaining reading at all. But somebody told me that there's a book which explains well about the common law principle. But I have not been able to get that book, and in the meantime, I have forgotten the name of the book also.
Is it an English law, under English law, or it's written in India?
No, Indian book, but to explain the common law. It's in volume 1 or volume 2 volumes, I am told. But it was in the Judicial Academy, the director told us, but I forgot the name.
It's complex, Lordship. There's no doubt about it. And ultimately, it comes down to at the end of the day, is what are the facts of the case? And ultimately, there's no straitjacket formula, Lordship. That's the real truth.
And the issue I've already told, I think I've told you why is this issue. You see, if you read the old edition of Evidence Act, if you can get hold of one, you will find that there was section 2 in the Evidence Act. It lays emphasis on the law of England. After I think at one point of time, this section 2 was repealed by a repealing act. It is only after that that the Indian law became paramount. Otherwise, Indian law would have its genesis to the English laws. And only with amendment to and repeal of section 2 of the Evidence Act, then our laws became paramount. Therefore, the question came as a student of law that if the parliament deemed it fit to repeal section 2 of the Evidence Act, why would then there would be a judicial interpretation to say that law of common law of England would be applied?
One sentence, if I may assist, in a similar, this Lordship, the pleasure of the crown. The pleasure of the crown doctrine initially, in its original form, was the minute the pleasure is withdrawn, you stand terminated. And up to the Government of India 1935 Act and thereafter, the pleasure of the crown, which also finds, that's why in its genesis in terms of the pleasure of the president or you're appointed, that lordship now has protection within the
We don't know, but you see, when you read Sirvai, volume 2, and when you read the issues of writ, there you will find a passage that there cannot be a writ against the crown. That is how it starts in Sirvai. And I have not found any judgment where it says that once a writ of mandamus is concerned, that has been diluted in English.
Yes, Lordship. The writ of mandamus also, Lordship, and one of the judgments I will be relying upon is specifically, and Rita Mishra, Lordship, which is, I was saying about the 2-judge bench of Bihar, full bench of Patna, 2 versus 1, which was upheld by the Supreme Court, deals with the writ of mandamus very well. So there's one judgment that we found that in a similar situation, the writ and the mandamus and its extent is dealt with. An old judgment, but 87, Lordship.
That was when I had a lot of time here, but now.
Lordship, I was reading, I just finished para 29, and I was in the middle of para 30 of Ashok Kumar Sonkar versus Union of India. And Lordship, we just note between placentum D and E. I was reading there, Lordship, para 30, which relies on the Karnataka SRTC case. And I'll just repeat from where I'd said that the principles of natural justice are furthermore not required to be complied with where it will lead to an empty formality. What is needed for the employer in a case of this nature is to apply the objective criteria for arriving at the subjective satisfaction. And I explained, Lordship, the applicability to our case. If the criteria required for arriving at an objective satisfaction stands fulfilled, the principles of natural justice may not have to be complied with. Please mark this, Lordship. If the criteria required for arriving at an objective satisfaction stands fulfilled, the principles of natural justice may not have to be complied with, in view of the fact that the same stood complied with before imposing punishments with the respondents on each occasion, and thus the respondents therefore could not have improved their stand even if a further opportunity was given. So it is, if the facts are such that they speak for themselves, if the facts are such that they lend credibility to the concerns, and if those facts point towards the non-qualification of the appellants in terms of their entry, and if it is done in a manner that lends itself to credibility, that is, it is not the targeting of an individual, it is not driven by a malafide exercise, it is not driven by any extra consideration, then, Lordship, the applicability of the principles of natural justice may be dispensed with. And in this case, they have further said, if they could not have improved their stand, even if there is a further opportunity was given. And just to add one more sentence, Lordship, the documentary evidence against each one of the appellants is that the answer sheets stand replaced. Their handwriting stands confirmed by the FSL or the forensic. The fake answer sheet being replaced, the original not being there, that lordship broadly points credibility in terms of the investigation. Now in trial, and I'll complete that argument, lordship, in trial, the considerations would be of beyond reasonable doubt. And lordship, I must point out in fairness, this argument also has been professed in cases that what happens if I am acquitted at the end of the trial? Will I get my job back? Respectfully, lordship, the Honorable Supreme Court has settled that too. State of Rajasthan versus Himsi. No. Even if you are declared that, you will not get your job because the consideration is not the individual interest. That is the critical point, lordship. The consideration is not the individual interest. The consideration is the public interest with regard to the holders of the public office. And lordship, every time I then end by saying they are probationers. The objective of probation stands satisfied. The law on probation is settled. There is no concept of deemed confirmation. The condition precedent is that the satisfaction should be there. It isn't there. What more can the government, I ask myself, lordship, look for?
But incidentally, in a
I was
lighter note,
awaiting lordship's.
in a lighter note,
Of course, lordship.
incidentally, when these issues of so many photographs or speeches, they come to the House of the Parliament, these are flashed in the TV, we see it. But in those cases, we don't find any step, proactive step taken by the.
So, lordship, for that we need an investigation with reliance on the forensic reports. So, lordship, there is a good case that even in those cases, if there is a reliance. And second, lordship, and absolutely, lordship, I see where lordship is coming from. So, I will take it to the logical legal argument that flows from it. And lordship, the first part is, are you a probationer or a confirmed employee? That's the first part. And in this, and if you are not a confirmed employee, your rights are different as a probationer. They are very limited, lordship, till you are confirmed. Now, only issue that will come is what are the facts against you during the period of probation? You know the guy. So, I have shown one judgment also that is at a higher pedestal in terms of not being a probationer, lordship, and yet the dispensing of it on the ground that the appointment is illegal. Lordship knows that under Uma Devi, an irregularity can be regularized, but an illegality cannot. The principle is very clear, lordship. And that is going to be considered, lordship, very shortly when I read two more paragraphs. At the last out, exactly, this argument of illegality, irregularity will come. And lordship, on a human level, and I say this not as a submission, that even if one feels sympathy for the situation, the Honorable Supreme Court's words in the judgment is sympathy has no place. It can't be misplaced. So, lordship, we are on a different thing. It's not about the individual, and I must make it clear. There's nothing personal, lordship, as any one of us are here. We are doing our jobs in simply pursuing what is the stand of the case. And I must make that clear that this is not about the individual, because I must point out they don't have a right as an individual to occupy an office. The office is a public office. It is driven by considerations of public service. It is driven by consideration of public duty. And in any case, without prejudice, the writ jurisdiction cannot place the public interest at a lower pedestal than a personal interest. Yeah. Lordship, in Punjab National Bank, so this judgment, lordship, essentially I'm using in the facts of the case one, and second, more important, the law has been laid down in one judgment. Several judgments are covered. Like lordship, I'll come to Sachin Kumar, which is Justice Chandrachud's judgment. Again, it looks at this tainted, non-tainted, segregation, non-segregation. It covers the whole law, including Inderpreet Singh Keh law. So, Lordship, para 31. In Punjab National Bank versus Manjeet Singh, this court opined, the principles of natural justice were also not required to be complied with, as the same would have been an empty formality. The court will not insist on compliance with the principles of natural justice in view of the binding nature of the award. This was a case of award. Their application would be limited to a situation where the factual position or legal implication arising thereunder is disputed, and not where it is not in dispute or cannot be disputed. Now, Lordship may mark the next sentence. If only one conclusion is possible, a writ would not issue only because there was a violation of principles of natural justice. Now, Lordship, this takes it at another pedestal. That if the only issue is violation of principle of natural justice, the court has been cautioned by this in this judgment, don't go issue the writ. Only. Which means the larger considerations and facts all have to become, which is why I started with probational, Lordship. That's the most important critical fact of this case. Para 32. In PD Agarwal versus State Bank of India, this court observed the principles of natural justice cannot be put in a straitjacket formula. And Lordship, see how beautifully it's put. It must be seen in circumstantial flexibility. It has separate facets. In recent time, it has undergone a sea change. So, Lordship, I read this for circumstantial flexibility. Then it has further observed, Lordship may straight come to placentum C, where it quotes the judgment of Rajendra Singh versus State of MP. The principle of law is that some real prejudice must have been caused to the complainant. Now, Lordship, the word is not just prejudice. Now it has evolved to real prejudice, not the argument of a prejudice. It places it at a much higher threshold to be crossed by the appellant. Real prejudice must have been caused to the complainant. The court has shifted from its earlier concept that even a small violation shall result in the order being rendered a nullity. To the principal doctrine of audi alteram partem, a clear distinction has been laid down between the cases where there was no hearing at all and the cases where there were mere technical infringement of the principle. So now again, the court is using the term technical infringement. The court applies the principles of natural justice having regard to the situation, fact situation obtaining in each case. It is not applied in a vacuum without reference to the relevant facts and circumstances of the case. It is no unruly horse. It cannot be put in a straitjacket. Next para, the principles of equity in a case of this nature, in our opinion, will have no play. Sympathy, as is well known, should not be misplaced. Now, in the Sonkar case, after examining the principles of natural justice, the argument of principles of natural justice, finally the Honorable Supreme Court says that in terms of equity, so now the other consideration in the writ jurisdiction, Lordship, is equity. Sympathy, as it is well known, should not be misplaced. Lordship may be pleased to come to the last paragraph, para 34. And this deals with the irregular appointment, illegal appointment. It is not a case where appointment was irregular. If an appointment is irregular, the same can be regularized. That's the principle of Uma Devi. The court may not take serious note of an irregularity within the meaning of the provisions of the Act. But if an appointment is illegal, and Lordship, please see the harsh words. If the appointment is illegal, it is non-est in the eyes of law, which renders the appointment to be a nullity. Lordship, para 34. I was waiting. I thought Lordship may be referring to the iPad because I've noticed Lordship does during the hearing.
No, the disturbing part is the reference to S.L. Kapoor, which made me look into the case of S.L. Kapoor. SL Kapoor is incidentally a three-judge bench. And referring to SL Kapoor, it says that the two-judge bench says that the ratio has been diluted. Then therefore I am reminded, just let me check it up.
Lordship. And if Lordship wants me to assist Lordship on this tomorrow, I'll come back on it.
No, it's okay. We are not insisting right answer right now. Because this 2002 3 sorry, this Ashok Kumar Sonkar
Yes, Lordship.
is two-judge bench.
Yes, it is two judge. Yes,
So
Lordship.
this is three-judge bench, and it says that the ratio has been, there's a sea change in the ratio. Now we are reminded of the decision of Pranay Sethi five-judge bench, which says that the bench of a lesser sentence should have been well advised. And it's a very harsh language used.
And Lordship, towards the end, that's why I specifically referred to 30, although it doesn't rely on SL Kapoor in saying so, the code puts it very, very clearly in absolutely, and I use the word harsh terms.
But then which is to be followed, a three-judge bench or a two-judge bench?
Lordship, the only question would be in this case, as I would point to myself, Lordship, and then it is, of course, for Lordship to consider, that in a direct conflict between two, there is no question but the three-judge bench comply. No question about it. However, if the principle of law is being discussed over multiple judgments, so my reliance on Sonkar is not pitching it against SL Kapoor and therefore justifying the two-judge benches. My reliance on Sonkar is that in the facts of the case, what have they had? They have said they call it the useless formality. Later, the word empty formality comes. It says that sympathy will have no place. And if it's an appointment is illegal, it is void ab initio, non est, and a nullity. These are the three principles on a tainted entry. Now, when I apply the same to my facts, I find that I'm able to put forth an argument, which is that ultimately, with the facts of our case, the state's case, with the investigation revealing something, could there have been another outcome provided there was a compulsion of applying the principles of natural justice? And when they are probationers, that compulsion is not there. So I'm applying the legal principles on PNG. Because, Lordship, I mentioned yesterday, all of these issues will now start getting intertwined. The illegality of the appointment, the cancellation, segregation, principles of natural justice. 311 is going to follow, Lordship. Then the width of the writ jurisdiction. Under a mandamus, what can be done? That's why I made sure that I first finish with probation, which is my first leg and the most important leg. And that's pure in its form, if I may say. It does not touch anything else. It focuses on that. Everything else will get intertwined. And therefore, Lordship, if I just step back for a minute, if we read even Tulsi Ram Patel, they will rely, I will rely. If we read Shamsher Singh, they will rely, I will rely. As I'm saying, everywhere it starts then coming together. But some things remain black and white. The facts of this case, the fact that they are probationers, and the fact that even if the argument of principles of natural justice are taken, what is the outcome and what is the real prejudice? The word I'm again, very high threshold, the real prejudice that would have been caused in the light of the investigation. That's my summation of this. If, Lordship, I may proceed to now some subsequent judgments. Sonkar was, Lordship, 2007. Now I'm coming to 2009, Lordship, State of Chhattisgarh and others versus Dhirjo Kumar Sengar, 2009, 13 SCC 600. Now, Lordship, this is a very, some of these judgments, Lordship, we have to smile on the facts also. What all can happen, Lordship, when human ingenuity takes place. Now, Lordship, this is a judgment, may just make one note, Lordship, that this is a follow-up on the state of MP versus Shama Pardi. So this is a follow-up on Shama Pardi, 1996. And this 2009, Lordship. And this builds the argument, fraud vitiates everything. There was no trial to confirm the fraud. Now, fraud has a very high threshold, Lordship, in law. But here, just on the facts being so apparent, the Honorable Supreme Court says it is fraud. Fraud vitiates everything. Essentially, Lordship, in this case, the documents speak for themselves. No trial, no investigation, no inquiry, no show cause notice. The documents speak for themselves, and the court holds there is no violation of principles of natural justice. So, the word in fact used in this judgment is not just a fraud on the government in terms of the job, it's a fraud on the constitution. Now, Lordship, I may point out that through our case before the learned single judge, there have been some terms we have not moved away from it, but that was our stand also. That it's a colossal fraud. It's a fraudulent entry. They are the beneficiaries of a fraudulent process. And hence we have treated to be an illegality void ab initio. If Lordship may be pleased to come to the judgment. The facts are para 1 to 5. Now, Lordship, I may just make Lordship mark para 1 to 5, but I'll give Lordship the facts. There is a gentleman, Lordship, who dies issueless. His nephew goes ahead and takes a succession certificate, Lordship. Then he realizes that someone must have guided him, some lawyer only, Lordship, or a government officer, 2 people only could have given this guidance, that you can try to take a job on compassionate grounds. So he now becomes the adopted son, gets the job, but then eventually somebody looks at it and says that where is the document of adoption? You just can't manufacture something. How can it happen on a succession? So that job is taken back. And then he tries his best to retain it, fights the case, and reaches finally the Supreme Court. These are the broad facts, Lordship. Para 10, Lordship, may come straight. And then I will read from para 17, Lordship, to 20. So this is, Lordship, Justice Sinha and Justice M.K. Sharma. Para 17, in the aforesaid premise, the contention in regard to the breach of odi alterum partem doctrine must be considered. The principle of natural justice, although is required to be complied with, it is, as is well known, has exceptions. Then, Lordship, relying on S.L. Kapoor. Let's now, therefore, I thought, Lordship, we'll come to this. In our view, the principles of natural justice know of no exclusionary rule dependent on whether it would have made any difference if natural justice had been observed. The non-observance of natural justice is itself prejudice to any man, and proof of prejudice, independently of proof of denial of natural justice, is unnecessary. It ill comes from a person who has denied justice that a person who has been denied justice is not prejudiced. Now, Lordship, let's see what S.L. Kapoor holds. As we said earlier, where on the admitted or indisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible, the court may not issue its writ to compel the observance of natural justice, and then in italics, not because it is necessary, not because it is not necessary to observe natural justice, but because courts do not issue futile writs. So, Lordship, here they have quoted S.L. Kapoor, and within S.L. Kapoor, the exception has been laid out and it has been linked to the writ jurisdiction. Then, Lordship, in para 18, I can leave it, Lordship, because it's a fact. Let's come to 19, Lordship. Based on the documents. Now, there is, Lordship, please bear in mind, no inquiry, no investigation, no trial. Now, only on the documents, what does the Honorable Supreme Court hold? Para 19. The respondent, keeping in view the constitutional scheme, has not only committed a fraud on the department, but also committed a fraud on the Constitution. Now, this argument, Lordship, may resonate even from our side in terms of, because it's a public office and it's governed by the provisions of the Constitution. And they are invoking the constitutional provision of 3112. So it says the respondent, keeping in view the constitutional scheme, has not only committed a fraud on the department but also committed a fraud on the constitution. As commission of fraud by him has categorically been proved, and I am using the words carefully, Lordship. The Lordship says proved on what? No inquiry, no show cause notice, no trial. Document. In our opinion, the principles of natural justice were not required to be complied with. 20. Mr. Gupta has relied on a large number of decisions of this court and Lordship may mark, including Inderpreet Singh Kehlo versus State of Punjab. This is a heavily relied upon judgment by the other side. Last line, Lordship. And also, Lordship may note in the second sentence, State of MP versus Shama Pardi. That's relied upon. Then, to contend that the Audi Alterum Partem doctrine should have been complied with. In these cases, requirement to comply with principles of natural justice has been emphasized. The legal principles carved out therein are unexceptional. But in this case, we are concerned with a case of fraud. Fraud, as is well known, vitiates all solemn acts. Quoting certain judgments relying on it, the High Court therefore must be held to have committed a serious error in passing the impugned judgment. Next, Lordship, 23. The very fact that the respondent had filed an application for grant of succession certificate along with his father, showing themselves to be the heirs and legal representatives of the deceased, is itself sufficient proof to show that he did not claim any benefit in regard to the debts of the deceased as his adopted son or otherwise. And then, Lordship, even costs is allowed. So, Lordship, just to close that, no inquiry, no investigation, no police report. At the lowest, Lordship, the Honorable Supreme Court has said that this is a fraud based on the documents. Then, Lordship, if I can request Lordship to come to the next judgment. This, Lordship, is Sachin Kumar and others versus the Delhi Subordinate Service Board, Lordship. 2021, 4 SCC 631. This is of Lordship Chandrachud and Justice M.R. Shah. I am, Lordship, moving beyond the facts. Ultimately, the examination was scrapped. There was mass fraud. But this judgment, Lordship, has dealt with all the preceding judgments and the law, including Inderpreet Singh Kehlo, all of it. And therefore, Lordship, at a single place, right up to 2021, the law from 1994 onwards, Krishan Yadav, including Inderpreet Singh Kehlo, everything is considered. $35.
Detection. I can result in action taken to exclude those whose credential or performance were tainted.
Then Lordship may just come to para 2, which deals with the overall arching facts, Lordship, and the principles that Lordships were considering, which they later then rely on the past precedents and finally pass the judgment. Once Lordship is on para 2, yellow, para 2. This judgment visits a familiar conundrum in service jurisprudence. The constitutional values which undergird Articles 14 and 16 mandate that selection processes conducted by public authorities to make appointments have to be fair, transparent, and accountable. All too often, human fallibility and foibles intrude into the selection process. Selection involves intense competition, and there is no dearth of individuals who try and bend the rules to gain an unfair leap in the race. Irregularities in the process give rise to misgivings over whether the process has denied equal access to all persons. The sanctity of the selection process comes under a cloud. The detection, and Lordship may mark this, the detection of individual wrongdoing by candidates may result in action being taken to exclude those whose credentials or performance is tainted, which is the segregation point, Lordship. And Lordship may note that this is the first step before an exam is to be cancelled. If you cannot identify, you cancel. But when the entire process is tainted, the authority in charge of conducting it may decide to cancel the selection as a whole. Judicial review is then invoked to challenge the decision to cancel the entire process. The guiding principles have evolved over the past 5 decades as new challenges emerged and novel attempts to suborn the legitimacy of recruitment processes have come to the fore. The Delhi High Court in the present case upheld the view of the Central Administrative Tribunal that the cancellation of the entire process was invalid, but it confined the relief to 6 candidates who had moved the proceedings before the tribunal in the first instance. Like other cases of its genre, this batch of appeals calls for the court to balance 2 competing considerations: the need to preserve public confidence in the sanctity of the selection to public posts and the requirement of observing fairness to candidates who invest time and resources in attempting to clear through a selection. Both these considerations have a constitutional foundation going beyond service and administrative law principles. The issue has traveled to the court for resolution, and the path ahead requires us to revisit and evolve the law on the subject. So this one paragraph, Lordship, in its sweep, looks at all the considerations, and Lordship, it deals with the law from para 35, and eventually, Lordship, I may point, it rejects and overturns the decision of the Administrative Tribunal and the High Court and says that the cancellation of the selection entire process should have been done. Para 35, Lordship, which is heading the position in law. 35, Lordship. That's where Lordships have placed the position in law. Lordship, it makes interesting to read it in entirety, but I will read 35 then 41 just to save judicial time, but that's the position of law in its totality. May I read, Lordship? In deciding this batch of SLPs, we need not reinvent the wheel. Over the past 5 decades, several decisions of this court have dealt with the fundamental issue of when the process of an examination can stand vitiated. Essentially, the answer to the issue turns upon whether the irregularities in the process have taken place at a systemic level so as to vitiate the sanctity of the process. There are cases which border upon or cross over into the domain of fraud, as a result of which the credibility and legitimacy of the process is denuded. This constitutes one end of the spectrum where the authority conducting the examination or convening the selection process comes to the conclusion that as a result of the supervening event or circumstances, the process has lost its legitimacy, leaving no option but to cancel it in its entirety. Where a decision along those lines is taken, it does not turn upon a fact-finding exercise into individual acts involving the use of malpractices or unfair means. Where a recourse to unfair means has taken place on a systemic level, it may be difficult to segregate the tainted from the untainted participants in the process. Large-scale irregularities, including those which have the effect of denying equal access to similarly circumstanced candidates, are suggestive of a malaise which has eroded the credibility of the process. Now, Lordship may mark, at the other end of the spectrum are cases where some of the participants in the process who appear at the examination or selection test are guilty of irregularities. In such a case, it may well be possible to segregate persons who are guilty of wrongdoing from others who have adhered to the rules and to exclude the former from the process. In such a case, those who are innocent of wrongdoing should not pay a price for those who are actually found to be involved, not Lordship, held to be guilty under court, involved in irregularities. By segregating the wrongdoers, the selection of the untainted candidates can be allowed to pass muster by taking the selection process to its logical conclusion. This is not a mere matter of administrative procedure, but as a principle of service jurisprudence, it finds embodiment in constitutional duty by which public bodies have to act fairly and reasonably. A fair and reasonable process of selection to the posts subject to the norm of equality of opportunity under Article 16(1) is a constitutional requirement. A fair and reasonable process is a fundamental requirement of Article 14 as well. where the recruitment to public employment stands vitiated as a consequence of systemic fraud or irregularities, the entire process becomes illegitimate. On the other hand, where it is possible to segregate persons who have indulged in malpractices and to penalize them for their wrongdoing, it would be unfair to impose the burden of their wrongdoing on those who are free from taint. To treat the innocent and the wrongdoers equally by subjecting the former to the consequence of the cancellation of the entire process would be contrary to Article 14, because unequals would then be treated equally. I am pausing for a minute, Lordship. We are at the other end of the extreme, which is where the identification could take place. Unlike cases where it is difficult to segregate, that identification takes place, they are probationers, they are discharged. Sometimes, and it has come also before the learned single judge, that the question arises, why didn't you cancel the entire examination? And this is an argument that reverberates. And in that, Lordship, this paragraph becomes critical, because then it is treating unequals as equals. It is undoing or disregarding the settled law that if you can identify and segregate the tainted from the non-tainted, you don't cancel the examination and you don't take, in a sense, punish those who are made it without any taint into the process, because then it is a negative sort of argument of Article 14. So, Lordship, we can now proceed to para 41, which deals with Inderpreet Singh Kehl. I'm sorry, Lordship, this deals with Rajesh versus PU, and then it will come to Inderpreet Singh Kehl. Lordship, right up to 41 are different cases, but I'm just relying on the ones that I feel are most focused to our arguments. May I read, Lordship? On the other hand, the judgment of a two-judge bench of this court in Union of India versus Rajesh PU involved a situation where a selection list consequent to a written examination, interview and physical fitness test for filling up the posts of constables in the CBI was cancelled. Due to, now here Lordship is reverse. The whole list was cancelled due to allegations of favoritism on the part of the officers conducting the physical efficiency test and irregularities in the written examination. A challenge to the cancellation failed before the tribunal, upon which proceedings were initiated before the High Court. A committee was appointed by the director CBI. Please pause, Lordship. This is an internal committee. Now, that exercise is about the subjective satisfaction within the department. And in the government, that subjective exercise is done in any case. It's not an individual taking a decision. Which upon meticulous examination found that 31 candidates who were otherwise ineligible were included in the selection list and an equal number of eligible candidates were ousted. In this background, the High Court found that there was no justification to cancel the entire selection when the impact of irregularities which had crept into the evaluation of merits could be identified specifically and was found on verifying the records to have resulted in 31 candidates being selected undeservingly. Upholding the view of the High Court, a two-judge bench of this court held in Rajesh PU case, in light of the above and in the absence of any specific or categorical findings supported by any concrete or relevant material, that widespread infirmities of an all-pervasive nature, which could be really said to have undermined the very process itself in its entirety or as a whole, and it was impossible to weed out the beneficiaries of one or the other irregularities or illegalities, if any, there was hardly any justification in law to deny appointment to the other selected candidates whose selections were not found to be in any manner vitiated by one or other considerations. So therefore, the court is holding, Lordship, that you have to try the exercise of segregation and you can't take the easy way out. That is, cancel the exam. You can't. That is the easy way out, in a sense. You just simply cancel the exam. Segregation is a more detailed exercise. Applying a unilaterally rigid and arbitrary stand to cancel the entirety of the selections, despite the firm and positive information that except 31 of such selected candidates, no infirmity could be found with reference to others, is nothing but total disregard of relevancies and allowing to be carried away by irrelevancies, giving a complete go-by to contextual considerations, throwing to the winds the principle of proportionality. In going further, than what was strictly and reasonably to be meet the situation. In short, the competent authority completely misdirected itself in taking such an extreme and unreasonable decision of cancelling the entire selections, wholly unwarranted and unnecessary, even on the factual situation found too, and totally in excess of the nature and gravity of what was at stake, thereby virtually rendering such decision to be irrational. Now, Lordship 43 deals with Inderpreet Singh Ken. The decision in Inderpreet Singh Kehlon versus State of Punjab, again of a two-judge bench, involved a case where it was alleged that the chairperson of the Punjab Public Service Commission had got a large number of persons appointed on the basis of extraneous considerations between 1998 and 2001. The state government cancelled the entire selection for recruitment to the PSC Executive Branch and Allied Service. 2 scrutiny committees were appointed, and on acceptance of their reports, the services of those who were appointed on the basis of selection made by the Commission against vacancies for 1998 and 2000 came to be terminated. The full bench of the High Court dismissed the writ petitions filed by the selected candidate. In appeal before this court, Justice S.B. Sinha enunciated in the course of the judgment the basis for the services who had been put in place some years of service could be validly terminated. And para 41, Lordship. If the services of the appointees who had put in few years of service were terminated, compliance with 3 principles at the hand of the state was imperative. What are those 3 principles? 1. To establish satisfaction, and please Lordship may mark, in regard to the sufficiency of materials collected. The satisfaction is in regard to the sufficiency of the materials collected, so as to enable the state to arrive at its satisfaction that the selection process was tainted. Now, in our case, that sufficiency of materials that is collected through the investigation enabled the state to identify the tainted entries and then segregate them from the rest. That is the first thing. Second, Lordship, to determine the question that the illegalities go to the root of the matter which vitiate the entire selection process. Such satisfaction as also the sufficiency of materials were required to be gathered by a reason of a thorough investigation in a fair and transparent manner. Now there are 3 steps, Lordship. First is at your level. Then if you want to consider to cancel the exam, the sufficiency of the material must point towards that it goes to the root of the matter. Then you must have your satisfaction that we cancel the exam. 3. Whether the sufficient material present enabled the state to arrive at a satisfaction that the officers in majority have been found to be part of the fraudulent purpose or the system itself is correct. Now, Lordship, approximately, if I recall the figure, 371 and 180 were the total number of people who made it. I say that, right? And Lordship, the total number of identified beneficiaries is 54. It's not the majority. So, Lordship, Inderpreet Singh Kehlon also is not one that you can argue and say that that is the law, because Inderpreet Singh Kehlon finally, Lordship, in Joginder Pal Singh, Lordship, when para 17, Justice Sikri clearly makes it clear, 17, para 17 only, 17, makes it very clear that if you have identified the tainted, there is nothing else left, and then dismisses. So, Lordship, in that particular case, I would also at this point just leave it with one sentence. That, Lordship, there is Amarveer, then Inderpreet, then there is Amarveer 2, and then there is Joginder Pal. So, Lordship, like a series of movies also, Lordship, you have to finally see the final part.
That is very well explained by Mr. Mishra, very lucidly explained. So therefore, that's a point very clear.
Where did that? So, Lordship, we may proceed to the next paragraph, para 45. The court noted inter alia the decision of Anamika Mishra where tainted cases were separated from the non-tainted ones, and only where it was found impossible or highly improbable could en masse orders of terminations have been issued. Hence, in the view of this court, an effort should have been made to segregate the tainted from the non-tainted. that effort is a, if I can say, Lordship, a sine qua non to the, before arriving at a decision whether you cancel the entire examination. The decided cases were broadly categorized. Now, Lordship, I won't read all of it, but very interesting to point out. The decided cases were broadly categorized along the following lines. And Lordship may see para 52, cases where the event has been investigated and may come to point B, Krishna Yadav versus State of Haryana, and point E, Union of India versus O Chakradhar. I've relied on both. Second, Lordship, is Roman 2, cases where CBI inquiry took place and was completed on a preliminary investigation was concluded, O Chakradhar and again Krishna Yadav. Now, Lordship, again, that is something we rely on, and we have done our inquiry in terms of the police investigation. 3, Lordship, Roman 3. Cases where the selection was made but appointment was not made. Does not apply to our case, Lordship. 4, cases where the candidates were also ineligible and the appointments were found to be contrary to law or rules. Again, Lordship will note Krishna Yadav and O Chakradhar. So if I may say, Lordship, these two judgments have stood the test of time from 1994. We are in 2021 now. And in these categories, these cases broadly see a lot. In fact, in Krishna Yadav, disgorging of the benefits of the officers also has been taken. Although that action the state may or may not have taken, I'm not sure. But the Supreme Court certainly said you can disgorge them of their benefits. Now, Lordship, para 46 acha hai. What is it? Well, Lordship, 46 repeats exactly what we have said, that you have to remove the, cancel the entire examination. But we'll come to para 48. In fact, Lordship, I will request you to come to para 47, the last 5 lines, and then we'll read 48 because it flows from there into 48. Lordship, the 5th line is, Lordship, near placentum D, having made this distinction, it must also be noted that the judgment, which is Inderpreet Singh Kehlo, emphasizes that where it is possible to segregate the tainted from the untainted candidates, the state must make an effort to do so. Both the judges, in fact, observed that performing this task was not impossible in that case. In that context, the final directions to do so were passed. Para 48. The sequel to Inderpreet Singh Kehlo is another 2-judge bench decision in Joginder Pal versus State of Punjab. After the decision in Inderpreet Singh Kehlo, a committee of 3 judges of the High Court was constituted to separate the tainted from the non-tainted candidates. As this court noted in Joginder Pal, the committee could pinpoint those candidates who had got selected, were selected for oblique considerations, and Lordship may mark. In other words, candidates against whom no taint was found had been selected on merits on their performance in the written examination and interview. Yet the committee came to the conclusion that the entire process of selection was a product of a well-planned scheme of deception, forgery and fraud, and therefore deserved to be set aside in its entirety. As a result of this report, the original writ petitions were reheard following the remand by this court in Inderpreet Singh Kehlo and were referred to a 5-judge bench. The writ petitions of the tainted candidates were dismissed by the High Court, but even in the case of the non-tainted candidates, it was held that the government was entitled to cancel the entire selection process once it was found to be vitiated by deception, forgery and fraud. The conclusion of the High Court in regard to the tainted candidates was affirmed in the judgment of this court in Joginder Pal, authored by Justice Sikri. Lordship, this is the critical part. The judgment of this court held that by directions which were made in Inderpreet Singh Kehlo, an effort was required to be made to segregate the tainted from the non-tainted. Justice Sikri held that 2 conclusions of the High Court were antithetical. Once it was found that segregating the tainted from the non-tainted is possible and was also achieved, the other conclusion to set aside the entire process was incompatible. The court held that the issue of the entire selection process being vitiated would have arisen only if the findings of the committee were that it was not possible to distinguish the cases of the tainted from the non-tainted candidates. The court held that the reasons for holding the entire process should be vitiated were the same as those which had been urged before the High Court earlier. Moreover, a crucial development which had taken place after the remand was that the state had come forward and indicated its willingness to take back candidates who were not tainted and were selected on the basis of the merit. In this background, the order passed by the High Court was set aside. So, Lordship, finally, the whole purpose of these 4 judgments and the up and down between the High Court and the Supreme Court was to identify who is the tainted, who is the not tainted. And it was finally, when that exercise was done, the Supreme Court in its final judgment says that once you have identified the tainted with the non-tainted, how can you punish the undeserving and set aside the whole exam?
It is difficult.
And Lordship, the remand back was for this reason. So the argument which comes from the appellant side that a High Court committee was required and that exercise is a condition precedent, in a sense, that word is not used. Lordship, respectfully, does not apply. This exercise had to be done. In this case, there were also judicial officers, which is how the High Court came into the picture. Had it not been a case involving judicial officers, and Lordship, in the consistent line of judgments, nowhere any court has said that a court must do that, or that an inquiry, in the nature of an inquiry, show cause notice, reply, proceedings, has to be done. The inquiry is of the limited nature to see the sufficiency of materials before the appointing authority to arrive at a decision. And in the case of probationers, that has been done in its totality. The objective has always been in Inderpreet Singh Kehlo and the Amarveer and the entire Joginder Pal judgments, Lordship, segregation, which we have done. So, Lordship, in fairness, our stand is that these judgments require that segregation to be done. We did that at the threshold before we took action.
17 onwards, Joginder Pal. FIR, straight away, dismiss kar diya.
And Lordship, later on, I'll come back to para 17 of Joginder Pal just to close this argument. That's the only relevant part, Lordship. Lordship, para 56. 53, Lordship. Okay, Lordship, I'll read. Yes, Lordship, para 56 we can go because 53 is also dealing with the same principle.
16 judgment ko ek saath compile kar.
Because, Lordship, it is 3 judgments compiled together. I'll read para 56. The decisions in the Railway Recruitment Board, Gohil and Kalaimani, 3 judgments, Lordship, all go to emphasize that a recruiting authority is entitled to take a bona fide view. Please, Lordship, may mark this. A recruiting authority is entitled to take a bona fide view based on the material before it, that the entire process stands vitiated, as a result of which a fresh selection process should be initiated. The integrity of the selection process cannot be lightly disregarded by the High Court, substituting its own subjective opinion on the sufficiency of material which has been taken into account by the decision-making authority. So 3 judgments, Lordship. The summation is this. Undoubtedly, fairness to candidates who participate in the process is an important consideration. There may be situations where candidates who have indulged in irregularities can be identified, and it is then possible for the authority to segregate the tainted from the untainted. On the other hand, there may be situations where the nature of irregularities may be manifold and the number of candidates involved is of such a magnitude that it is impossible to precisely delineate or segregate the tainted from the untainted. A considered decision of the authority based on the material before it, taken bona fide, should not lightly be interfered in the exercise of the powers of judicial review unless it stands vitiated on grounds of unreasonableness or proportionality. That lordship, and at the end of it, lordships in this judgment, they cancel the entire process. This was lordship up to 21. Now, if lordship may permit me to go back a little in time to 1987 lordship, because that judgment deals also with the writ of mandamus. It's a 3-judge of Patna High Court lordship. But what's important is it has been relied upon and upheld in a Supreme Court judgment of 2050. 20. I'm sorry, lordship, 2020. This lordship is Rita Mishra, 1987. Or we can take it as AIR, in 1987 SCC online, Patna 159. And lordship, it stands approved in State of Bihar versus Devinder Sharma, 2020, 15 SCC 466. Lordship, this is a very interesting case, so I'll save reading the facts. But the facts are interesting, lordship. With due respect, lordship, in that part of the world, these kind of scams did happen. But lordship, one enterprising government officer in the education department issued lordship letters of appointment which were completely forged and fabricated, appointing teachers.
We have had this here.
I think so, no? We're relying on it, no? Guwahati High Court. No, not here.
Lovely
No.
singer.
Lovely Singha is, I think it is Lovely Singha is a teacher's case. Yes, lordship, you're right. But lordship, this one, the argument, I'm sorry for smiling so much, but the argument is also, I would say, unique to that part of the world. So lordship, you have a fraudulent forged appointment of letter and you draw your salaries. The fraud comes to the light of the government and a writ is filed by one who's the beneficiary of the fraud that I worked, so I should be paid my salary.
Same.
Lordship, somebody has taken inspiration. I'm going to take out that judgment, lordship. But today only we'll see on it. Which one? Is it Lovely Singha? It is Lovely Singha. That's what I thought. So. Yes, lordship, it is Lovely Singha versus State of Assam, 2020 SCC online, Guwahati. Justice Koteshwar Singh. At that time, I was acting chief, I think.
No, before that.
Even before that.
That was, I think, Honorable Justice Ranjan Gogoi.
I'm going to read it today because this one I was very taken in by.
You will know those teachers' cases, court number 4. Okay.
Fraudulent teachers' appointments. Lordship is saying perhaps Justice Gogoi
was dealing with that. I have to look into it.
I'm going to search it today, Lordship. It's of interest to me because I'm relying on I want to see the commonality of the facts. I'm very grateful for that, Lordship. So, Lordship,
directions were issued and then the cancellation took place.
These people are claiming salary.
So, these people are claiming salary. They don't want the job. They came and said, "Humne kaam kiya, humko paisa do." Lordship, the first paragraph makes quite interesting and pleasurable reading. This is the majority view, Lordship. Whether a public servant is entitled to a writ of mandamus for the payment of salary to him for work done despite the fact that his letter of appointment was forged, fraudulent, or an illegal one, is the significant question in this set of 13 connected writ petitions referred for an authoritative decision to the full bench. I have told Lordship the facts. Broadly, Lordship, those facts are what I said in 2 sentences. It's para 1 to 8. And para 9 onwards, Lordship start laying down what they think. Para 9, Lordship. With the deepest respect, it seems to me that on principle, the aforesaid stand has only to be noticed and rejected as wholly untenable. Lordship, is it the same paragraph? That's why, right, okay. However, since the issue has been pressed with great vehemence before us, that's on the salary, Lordship, and support therefore does appear in somewhat cryptic though axiomatic observations in a number of interim orders passed at the motion stage within the High Court, it becomes necessary to extend the complement or a rational refutation thereto. Now, Lordship, there are three categories in para 10. It would perhaps be apt first, for the sake of clarity, to consider the issue of seriatim, the issue seriatim in the declining order of gravity. Here we are primarily concerned with three categories, and one may examine the issue separately. In context, whether the appointment letters are either 1. Expressly forged and thus amounting to a crime, have been obtained fraudulently or for dubious considerations but not amounting to a criminal offence, or are otherwise illegal, being flagrantly violative of the statutory procedure. Taking up the first category of appointment letters which are established to be forged, it would perhaps appear that this is further divisible into two categories, subcategories, namely those where the appointee is directly a party or privy to the forgery. So, Lordship, see the subcategories. That's why I'm reading this para. Those who are directly a party or privy to the forgery. So I'm drawing the corollary, those who are actively and directly involved in the rewriting of the exams process, etc. There is a separate category, Lordship, not before Lordships, before the single judge, where there is an argument of enhancement of marks. Now there the argument is taken, I did not enhance the marks, I was not there. There is no proof of my handwriting or anything like that. So, Lordship, and where in fact he is not so. Adverting to this first subcategory, it is plain enough that a forged document is non-est and a nullity. As would be elaborated hereinafter, forgery apart from rendering the document of no value is also a punishable crime. To my mind, a relief in the extraordinary, and this is where the writ jurisdiction starts, Lordship. To my mind, a relief in the extraordinary writ jurisdiction cannot be possibly rested on the foundational base of a crime. Please, Lordship, may mark this. The foundational base of a crime. Without being dogmatic, it appears to me that this proposition is so elementary that I confess on being somewhat surprised at the logical temerity of the petitioners to claim that even if a letter of appointment stems from a serious punishable crime, still their right of salary cannot be denied because they have actually worked on posts on the basis of such a crime. Not only that, the claim is that a mandamus in the writ jurisdiction must issue to enforce this purported right of salary, therefore, preemptively. It would perhaps be apt to keep in mind, in focus, two basic legal propositions for which neither authority seems to be needed nor any great elaboration is called for. The right to salary stricto sensu springs from a legal right, please mark, Lordship, to validly hold the post for which salary is claimed. It is indeed a right consequential, please mark, Lordship, to a valid appointment to such a post. Therefore, where the very root is non-existent, there cannot subsist a branch thereof in the shape of a claim to salary. Consequently, and Lordship may mark, if the very foundational right to hold the post is fouled by the crime of forgery, no consequential right to salary can possibly emanate therefrom. In such a situation, the question is not that the appointee allegedly purported to work against the post on the basis of forgery, but, and Lordship may mark, the real question is whether he was at all entitled to so work and has lawfully worked thereon. The litmus test would be whether, when specifically challenged, the claimant can show and uphold his lawful right to the post, and thereafter alone can he possibly seek the ancillary claim of salary flowing therefrom. This paragraph, Lordship, sets in place in crux, while here the demand was for salary, in this case, here the demand is for reinstatement. And everything, Lordship, in this paragraph is pointing to the entry point, to the service. And it goes on to define it that if the foundation is basically criminal, or if the foundation is tainted, you can't claim the ancillary benefit of the branch if the root, which is, Lordship, the fruit of the poison tree. Lordship, we may come to para 15. It builds further on this, and then it'll come on to the mandamus lordship. To sum up on this aspect, it seems somewhat plain that where the letter of appointment is a forgery and the appointment is a, lordship may mark its party, not partly. So the appointee is a party. It's a typo. And privy to the same, no substantive right of salary could arise. However long the person may have fraudulently worked on the post in actuality. Lordship, now the next part is what I rely on. To my mind, no legal right can stem from a crime herein because of the original factum of forgery. Such a person is not an employee at all and far from being a public servant in the eye of law. Even if on the basis of a forged letter he has imposed himself on the post and worked thereon, he cannot take advantage of his own wrong because he could not have lawfully worked thereon. Para 16. As regards the subcategory where the appointment letter is established to be forged, but the appointee is not a party or privy to the same, the position would be only a step down the ladder. Step down the same ladder. What has been said above would mutatis mutandis apply to this situation as well. As observed earlier, the very forged letter of appointment itself is non-est and a nullity, and therefore no consequential right or statutory salary stricto sensu can flow from it. This is so on the basic principle that, please mark lordship, public service is a matter of status and governed by statute, and no rights of this nature can stem from a crime. Lordship may then come to para 17A. May I, Lordship?
You'll find it, I remember the reference. Manoharan Committee report.
Manoharan Committee report.
After this Manoharan Committee reports,
Manoharan or Manoharlal?
Manoharan.
Manoharan.
Manoharan. He was the Lower Assam Commissioner, if I remember correctly. He, because of the cabinet decision, he was appointed. He took, I think you were the Education Council then. No, after that, in these cases, you were the counsel for Education Department. And
Regular, irregular, and all
Ah.
3 parts are there.
and in this case, interesting things happened. There's a judgment, I think by Justice Patnaik, as he was then. In this case, the officers who were tainted for having done the scam, thousands of appointments illegal, they were compulsory retired, and this court held that they couldn't have been compulsory retired because of that taint involved, and therefore DP is not a case of compulsory retirement.
They were confirmed employees.
So no, compulsory retirement itself, that also was not.
56J also was not happening. I'll read it, Lordship. Because now that Lordship.
That's one, and thereafter came all those cases, but then subsequently the court changed its view and said that you don't have a right of appointment. But
Because Lordship, that comes from the General Clauses Act.
I won't remember so much.
Lordship, and I would be showing that towards the end. The General Clauses Act, basically, if you have the right to appoint, you have the right to remove. I mean, to put it in one sentence. That is really the General Clauses Act. So it's very clear on that. And therefore, Lordship, when that exists in the General Clauses Act, the protection is what happens after you've been confirmed, which is where the protection comes in. Lordship, if I may request Lordship to para 17A. It is unnecessary to multiply authority, and there is no dearth thereof, that fraud would thus vitiate every bilateral right. I like this use of term, Lordship, bilateral right, arising from a contract. Once it is so held, rights springing from law and status and the high pedestal of public employment, having a statutory base, deserve even greater protection and sanctity. Consequently, it must be held in no uncertain terms that where the source of the right is rooted in fraud or established dubious considerations, no right stricto sensu for salary can arise, and far less be enforced by way of mandamus in the jurisdiction. Adverting now to the last category, where the letter of appointment is illegal and being flagrantly violative of the statutory procedure prescribed for selection and appointment, again the position does not appear to be materially different. It bears no repetition, and reiteration that the statutory right to salary in public service stems from the legal right to hold the office if it is once held that the very threshold stage of the appointment is illegal, then there is no eye of law. There is in the eye of law no appointment to the post or entry into public service. The door stands barred and slammed in the face of such an intruder. It was contended forcefully that where the procedural requirements of selection and appointment are statutory and have not been complied with at all, there is no appointment in the eye of law. Consequently, no right of salary stricto sensu can arise before the very threshold stage is tainted with illegality. So, Lordship, this is a judgment where the threshold is being spoken of. Lordship may come further to para 21. No, Lordship, we can go ahead to para 23. Para 23, Lordship. Okay. 25A?
25A.
Lordship, 25A. We are just saving judicial time, Lordship, because the point is well professed up. It's a repetition of that. And I know Lordship will again be under pressure very shortly. I am also under pressure to try and finish more. Para 25A. The primary, now this is on the writ of mandamus, Lordship.
That situation.
What is it in a situation like this? The primary scope and function of writ of mandamus has been pithily expressed in the phrase that this writ is issued to command and execute and not to inquire and adjudicate. So, Lordship, we were searching for other judgments, but I must respectfully say that here in these two paragraphs, it has written it very, very pithily. It is to command and execute and not to inquire and adjudicate. It is not to establish a legal right, but to enforce one. It is only where the legal public duty is clear, unqualified, and specific that a writ of mandamus can be truly claimed. That means it has to be so clear on the government that it is our duty that we should reappoint them or cancel the discharge, then the mandamus can be claimed. It is in the reverse, that the duty has to be at a very high threshold. It is not for adjudicating in terms of looking at the rights. It is to make sure that if you have a right which is beyond reasonable doubt, which is in every sense a right that has to be complied with, it is an established right and not tainted in fraud, where it is the entry is not illegal, it is not resting on a crime. All these are the thresholds, Lordship. Reading further, Lordship. It is not to be granted where the claim of the petitioner has in fact to be first established and adjudicated upon before it can be enforced. As in the present case, a frontal challenge is laid to the petitioner's claim on every aspect, and the averments on their behalf are sought to be controverted at every step. It is manifest that first the petitioner's claim has to be gone into, adjudicated, and then established. That obviously is not scope of a writ of mandamus. Ferris in the Law of Extraordinary Legal Remedies has said, the office of mandamus is to execute, not adjudicate. It does not ascertain or adjust mutual claims or rights between the parties. If the right is doubtful, it must be first established as well as to enforce a claim of uncertain merit. It follows, therefore, the mandamus will not be granted where the right is doubtful. Doubtful. Even doubt is enough. Then, Lordship, equally instructive is to notice the scope, and Lordship, we are now on to Halsbury's. And we may read Halsbury's, Lordship. The order of mandamus is an order of a most extensive remedial nature and is info a command issuing from the High Court of Justice directed to any person, corporation or an inferior tribunal requiring him or them to do some particular thing therein specified which ascertains to his or their office. And Lordship may mark the next part, which is what I really rely on, and is in the nature of a public duty. The statement of law on the scope of mandamus in corpus juris secundum is as a writ commanding the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station. It is a proceeding to compel someone to perform some duty which the law imposes on them, and the writ may prohibit the doing of such a thing as well as command it to be done. It is evident from the authoritative exposition of law that the sine qua non for the issuance of a writ of mandamus is the existence of a statutory or public duty devolving upon the person or the body against whom or which the said writ is directed. Equally settled it is that along with this, must coexist a corresponding right in the petitioners who were entitled to claim the enforcement of the said statutory duty. Unless these two preconditions are satisfied, the requisite foundation for a issuance of a writ of mandamus can hardly be said to exist. Applying the two twin test, Lordship, he says neither is satisfied. Para 27, Lordship. I would refrain from enlarging the examination on the issue of the principle because it seems to me that the matter is well covered by binding precedents on the scope and nature of the jurisdiction in a writ of mandamus. And Lordship, he is now relying on Supreme Court judgments. I'll just read the underlined part, Lordship, of the next page, which is, Lordship, a 1966 judgment. The reason is that, I'll read from there, Lordship. The reason is that a writ of mandamus may be granted only in a case where there is a statutory duty imposed upon the officer concerned and there is a failure on the part of the officer to discharge the statutory obligation. The chief function of the writ is to compel the performance of public duties prescribed by statute and to keep the subordinate tribunals and officers exercising public functions within the limits of its jurisdiction. I'll just pause, Lordship. Let me reverse it and ask myself, Lordship, that assuming for a minute, Lordship, a writ of mandamus is, assuming, passed in terms of granting the plea of the appellants and casting the duty on the state that you reinstate them. Multiple things will come. As probationers, did they have a right? As probationers who were not confirmed as per the statutory rules and hence are not confirmed employees, do they have a right? 3, if the foundation of their claim to that public office is tainted, can they claim a right? 4, would it be in larger public interest that they are brought to occupy public offices? Would it help public trust? And 6, what is the duty on me in all these circumstances, given the settled law that I've undertaken the exercise of the segregation based on objective material, arrived at my satisfaction, and done it in public interest? So the scope of the mandamus is an extremely important scope. We come to the court on a daily basis invoking this, Lordship. We are before the court always against public authorities in our capacities as legal practitioners. But Lordship, that right has to not be something that has to be adjudicated. That right cannot be doubtful. That right cannot be founded on a crime, as this judgment says. It is an established right beyond doubt, and there has to be a consequential public duty beyond doubt. May I take Lordship further? To para 28. There is yet another. So Lordship, if I may say, this is like a 400-meter hurdle race, this judgment. In all these paragraphs from 25A, a new hurdle is put in terms of the arguments while invoking that really. Para 28, Lordship. There is yet another impassable hurdle in the way of the petitioners in this context as it stands already noticed. Every conceivable material fact averred on their behalf has been categorically contradicted and challenged in the pleadings and even more forcefully assailed at the bar. That's exactly how it fits in our case, Lordship. It needs no great erudition to see that the writ jurisdiction is clearly confined to facts alleged and admitted on affidavits or those not seriously traversed on the record. As it is well known, it is an extraordinary remedy resorted to when the basic factual position is not in dispute. It is to be borne in mind that the writ jurisdiction is not and cannot be made a substitute for a regular trial by way of a suit for determination of contentious matters in which the parties are diametrically opposed on material facts. And lordship may come to the next page top, starting with the last word on this page. It would be doubly so. Next page, lordship. So when a writ of mandamus is sought to be claimed, as was noticed earlier, a mandamus issues only to enforce an unqualified, established right, and not where the petitioner's claim has to be first adjudicated and thereafter established. Para 30. Now, once it is so that even a calculated and designed suppression of material facts in the writ jurisdiction would non-suit the petitioners, then it seems the more so that where the stand of the respondent state is that the claim is based on a punishable crime like forgery or fraud, the list cannot be gone into in the writ jurisdiction. This lordship squarely covers what we are arguing. Lordship para 44, which deals with now principles of natural justice. So it starts there, lordship may come to 46. That is the basic arguments, lordship, and the conclusion. In 46, lordship may come to subclause 5. On the procedural aspect. Has lordship got that?
Yes.
On the procedural aspect, where the basic and material facts are categorically controverted and traversed, the exercise of writ jurisdiction would be inapt, and this would be doubly so in case of a writ of mandamus which cannot possibly issue on such a slippery base. Lordship, para 46. To finally conclude, on the legal aspect, the answer to the question posed at the very outset is rendered in the negative, and it is held that the public servant is not entitled to a writ of mandamus for payment of salary to him for any work done in the event of his letter of appointment being forged, fraudulent, or illegal. Lordship may come to 49. Principles of natural justice. Because this was argued, and these are just the last 2-3 paragraphs, and I'm done with this judgment. A somewhat, para 49, lordship, a somewhat curious and a last-ditch attempt was then made on behalf of the petitioners to invoke the principles of natural justice. It was sought to be contended that the burden, instead of being on the petitioners, should be entirely shifted onto the shoulders of the respondent state. It was argued that it was incumbent that the state should have first held a full dress inquiry, and after affording a reasonable opportunity to the petitioners, should have established that the purported letters of appointment, which are admittedly in the petitioner's possession and within their special knowledge, are forged and fraudulent and illegal, and only thereafter the petitioner's salary should be denied and stopped. Para 50. This stand has only to be noticed to be rejected. Undoubtedly, the burden must lie on the petitioners that it is they who have to establish their claim on the basis of a valid appointment and not on the respondent state to prove the negative. The claim of a full dress inquiry after associating the petitioners in a writ of mandamus is plainly ill-founded and does not lie in the mouth of the petitioners. On principle and even on the basis of precedent on which reliance was placed by the petitioners too, it is wholly settled that where the very original appointment to the service is invalid or forged or fraudulent, then in the eye of law there is no appointment at all, and declaration by the state that the alleged appointment is non-est does not attract any principle of natural justice. And at the end, lordship, para 51, 52, they just simply dismiss the petition. The lordship, Rita Mishra, though a full bench of the High Court, but it has been upheld in the Supreme Court as recently as 2020. While the facts are somewhat different because there's a forged letter, in our case, they also match in terms of the arguments that we are placing before lordship and ladyship about the appointment being rested on a crime. The foundation so be that the appointment being tainted, and we have therefore lordship through these judgments, and I have only 2 more to show after this, also not just shown that where an appointment is illegal, it is void ab initio, but then the argument of principles of natural justice are covered. And Lordship, the argument with regard to the scope of a writ of mandamus in these specific facts, or such special facts, if I may say, Lordship, that has also been covered in my arguments. If Lordship permits, I'll go to the next judgment. I'm just seeing the watch behind. And if I can finish perhaps the Guwahati High Court judgment today, Lordship. Grateful, Lordship. So, Lordship, next is Lovely Singha versus State of Assam and others, 2020 SEC Online, Guwahati, 4958. And Lordship, I'm going to, again, in the interest of time, cut short some of the arguments, Lordship, paragraphs, and refer to them just for Lordship to know. Lordship may come straight to para 15. Lordship, all these appointments were teachers on non-existent posts. So, Lordship, there's a similarity of the facts of Rita Mishra and perhaps what Lordship just told us about the Manohar Run Committee. We'll check on that. Para 15, Lordship. This is again to Lordship lay down the argument that even this Honorable Court has rejected in a similar situation the argument of principles of natural justice. So it builds on Rita Mishra. 15, Lordship. Even assuming for a moment, in view of the contention raised that while terminating the services of the appellant, petitioner, the principles of natural justice were not followed, in that the appellant petitioner was not afforded a sufficient opportunity, the same is required to be considered in the backdrop of the fact situation obtaining in each case. In this regard, it is apt to refer to the following observations made by Honorable Supreme Court in Mohammed Sartaj. Now, Lordship, this is the repeat of what I have already read, which is, Lordship may note, Aligarh Muslim University versus Mansoor Ali Khan. I had read this, Lordship.
Yes.
So I'm not reading this, Lordship. Para 16, Lordship. No, Lordship, may just come to the end of para 15, 5 lines before the bottom of para 15. The principles of natural justice would be attracted only when the services of some persons are terminated by way of punitive measure or thereby a stigma is attached. Applying this principle, it could very well be seen that discontinuation of the service of the appellants in the present case was not a punitive measure, but they were discontinued for the reason they were not qualified and did not possess the requisite qualifications for appointment, which means basically a non-est appointment, Lordship. Para 16, in Nazira Begum Lashkar, Supra, the challenge was made about the appellants as assistant teachers. I'll leave this, Lordship. I just want to go to the next page to Placetum A. Just below that, what has been observed? What has been observed therein were that as the initial appointments had been made illegally, contrary to the statutory rules, the continuation of such appointees must be held to be totally unauthorized and no right accrued to the incumbents on that scope. Lordship, in para 18, they hold the appointments to be void ab initio, which is the last word in the paragraph 18. And Lordship, para 20 deals with negative equality. I'd like to read that. Para 20. A submission is advanced without, however, bringing any material to the effect that by virtue of Annexure A perpetually annexed to the order dated so-and-so, 5 other persons were also appointed. Is Lordship on para 20?
Yes.
So I've come to the next page, Lordship. 5 other persons were also appointed as assistant teachers in different lower primary schools by the then Deputy Inspector of Schools, Mangal Doi, like the appellant petitioner. But the services of those 5 persons are not terminated till date. And in such view of the matter, the order of cancellation passed in respect of the appellant petitioner who is also similarly situated, ought to be recalled. We do not subscribe to and accept such submission made on behalf of the appellant petitioner, whereby the appellant petitioner is claiming negative equality when Article 14 of the Constitution of India only embraces positive equality. And then, Lordship, in para 21, holding the appointment to be non-est, this Honorable Court dismisses it. I may just point, Lordship, that this argument also has been taken by the appellants to assail the continuation or the non-discharge of the approvers. So this argument, this judgment, Lordship, in the last paragraph, is there. I will show something additional also. But I just wanted Lordship to make a note of it. That the concept of negative equality will not work, and this court has held that view, Lordship. My last judgment, Lordship, in this series is Lordship Naresh Kumar versus Government of NCT 2022 SCC Online Delhi 4002. This is also Lordship Delhi High Court. It's a division bench, Lordship. And Lordship, I may just point that it has attained finality because there was no interference by the Supreme.
In both the
Both, Lordship, these matters. In fact, all the matters I'm showing, none of them had a challenge in the Supreme.
if I have a fair submission.
So, Lordship, is a very interesting case. Naresh. Again, I'll save you from leading the facts, Lordship. Just tell you the facts, Lordship. In a few sentences, I'll share the facts, Lordship. He's a bus conductor, Lordship. He is appointed. Now, Lordship, the question comes on two FIRs. The first one, Lordship, happens subsequent to him being appointed as a probationer. So, Lordship, he is a driver on probation. During the period of probation, an FIR gets registered on him. And then what also emerges is the second FIR that pre-existed to the probation. These are broadly, Lordship, the criminal cases and FIRs that come to light, and they are dealt from para 1 to para 8. Paras 10, 11 and 10 and 11 deal with the second FIR which was not disclosed. And in para 13, his arguments begin, and I will read that, Lordship, because many of those arguments are resonating even here. Learned counsel appearing for the petitioner submits that the challenge made to the impugned order of the petitioner is fourfold. He's been removed, Lordship, discharged. That the order dated 5/7/13 passed by the respondent is stigmatic and punitive and not a simpliciter termination order, thereby warranting issuing of a show cause notice before disciplinary proceedings could be initiated against the petitioner. Since non-issuance of a show cause notice followed by disciplinary proceedings is violative of the fundamental principles of service jurisprudence, hence termination should be set aside. Then, Lordship, the second ground of a thing relates to the rules. Come to 3, Lordship, Roman 3. That the allegation of non-disclosure of the criminal case bearing number so-and-so registered on so-and-so has also been made the basis of the termination, despite the fact that the concerned FIR was registered subsequent to the appointment and therefore could not have been made the basis of termination. And 4, that the maximum extension of probation of the petitioner beyond the maximum statutory period of 2 years would entail automatic confirmation on the post by the deeming legal fiction inbuilt in Regulation 7. So these are the 4 grounds. Now, Lordship, para 19. He argues that thus on the basis of the above, learned counsel submits that if the termination order dated so-and-so is examined on the touchstone of either the order not being simpliciter termination or on the basis of violation of regulation same, the same is liable to be quashed and set aside. So he prays that resultantly he may get full back wages. Now comes, Lordship, he is seeking reinstatement, Lordship, para 20. The argument of the state is it is non-stigmatic. And the discussion starts at 23-24. We propose, para 24, to take up the arguments raised in sub-para 1 and 4 of the para 12 above at the initial stage. Learned counsel for the petitioner argued that the impugned termination order issued to the petitioner, who was a probationer, was stigmatic one and therefore could not have been issued without a show cause notice to be followed by a proper inquiry. And the second contention is of deemed confirmation, para 26. The termination order records the aforesaid facts which are not disputed by the petitioner either. However, the substratum of the termination order is not based on such events and simply proceeds on the basis that the period of probation of the petitioner cannot be extended beyond 2 years, and as a result, the services of the petitioner were terminated under Regulation 9. Now, they in Lordship quote Regulation 9, and now let's see what they say in para 27. This is important, Lordship. A mere mentioning of such admitted facts without making the same as the basis for termination cannot make the order of termination stigmatic one. Learned counsel for the petitioner is not correct when he contends that since the termination order mentions the registration of the FIR, since the termination order mentions the registration of the FIR, it has to be considered as if the termination itself is based thereon. We do not find anything in the said termination order that can give rise to the presumption that the same was based on a criminal complaint and was not a simpliciter termination. Then Lordship in 28 they reject the argument of deemed confirmation. In 30 and 31 also, Lordship. Then Lordship, para 39. Actually, it is the end of para 38, but Lordship may come to para 39 and just refer to para C above that.
30,
So Lordship, basically,
39.
yes, Lordship. So basically, 38 starts quoting judgments of the Supreme Court, Lordship. It quotes Lordship Satyanarayan Jhavar, which is quoted in one of the judgments. It quotes Lordship Headmaster Lawrence School, which I have read also in one of the judgments. But next page, Lordship, why it's important, see, it relies on Durgabai Deshmukh Memorial, which I just read. Now, Lordship, para 29. So I'm just saying that the 39, Lordship. So, Lordship, I'm just showing that the identical judgments have been relied upon by the Delhi High Court also in a case of this nature. Upon a consideration of the law as laid down by the Constitution Bench of the Supreme Court, which is followed by other judgments and applying the same to the facts of the present case, the irrefutable conclusion we reach is that there is no deemed or automatic confirmation of the petitioner due to expiry of the maximum period of probation or its extension beyond the maximum period unless confirmed by clause 2 of regulation 7 of the regulations. It is beyond cavil that no such confirmation ever took place, and therefore termination by a letter dated so and so was in terms of regulation 9 and cannot be quashed as prayed. So they reject the argument. Then 43, Lordship. The aforesaid argument is only to be noted. This is on the termination being stigmatic. The aforesaid argument is noted only to be rejected since it proceeds on a fallacious ground. We have already held that the termination order is not predicated upon the criminal case and only records it as a fact. Therefore, reference to the registration of the FIR subsequent to the date of appointment does not further the case of the petitioner. Thus, we reject this too. Now, Lordship, all my orders which I showed were 3 lines, no mention also of the FIR. Here, the court has said, even though you have mentioned the FIR. So, Lordship, the argument is, now there are 2 categories. A category where nothing is mentioned, it's simpliciter discharge to a probation. And a category 2, where something is mentioned. What the court has held, at least what Delhi High Court has held, and it's a division bench, that what they have held is, Lordship, that the mere mention of it does not make it stigmatic. Especially when you are a probationer and there is no confirmation. So both the aspects have to be kept in mind, Lordship. Para 44. Since we have concluded that the termination order dated so and so is not stigmatic, as a corollary, we hold that the reference in para num of the FIR, which is referred to on so and so against the petitioner, as well as the reference in para 2 of the unauthorized absence from duty during probation period in the said order as surplusage and expunge the same. So what is the relief he gets? He doesn't get reinstatement. The relief he gets is, okay, you are aggrieved by this, delete that. That is the relief. The relief is not reinstatement. And in that they ordered and directed the authority to remove that relief. So I'm very grateful, Lordship, that I finished my second this, and I'm so grateful that Lordship and Ladyship were so gracious to give me some extra time today, Lordship. I am, Lordship, subject, as they say, Lordship, if you eat something sweet after dinner, then you don't stop at the first sweetness, you take the second one. So I'm praying Lordship would be as indulgent tomorrow also. And I hope then I can finish that.
Tomorrow is another day.
I know, Lordship. But then Lordship 007 continued in many more series thereafter. A little bit of lightness, Lordship, doesn't kill us in our onerous task on a day-to-day basis. I'm so grateful, Lordship, to Ladyship and Lordship.
It was.
Yes, yes. No, I don't think they'll do it.
That judgment your lordship was referring to, Finance Minister is Sudhanshu Mohan Talukdar versus State of Assam, reported in 2006 to GLP.
Maybe,
I'm not
because-
sure, I'll have to cross check.
Even
No, no,
Sudhanshu Talukdar.
Sudhanshu Mohan Talukdar.
Note Kallo, Sudhanshu Mohan Talukdar. We are also going to check. Thank you.
I won't remember because of those days. I was just backbencher. So whenever the good things were happening in the court, I was just watching and then something we remembered.
So, Lordship, in Yes Minister, he was a backbencher. Then he becomes a minister, eventually the Prime Minister, Lordship. What a wonderful series. So, one day, as Prime Minister, he's talking to his wife and he says that, but he's only a backbencher. He says, so what? And she says, they always say a lady will come with a conscience and remind him. Say that, what do you mean he's only a backbencher? You too were a backbencher a few years ago. So he then says, but I was the cream. So Lordship may perhaps also like to keep that corollary in mind. It didn't end as a backbencher.
It's just somebody was graceful.
Lordship, destiny. No question about that. Destiny.
We'll give you the names for the appellants. So and so for the appellants are present. No other appellants are represented. Next para. The submissions of Mr. N. Kohli and the senior counsel. You see from the last order, along with so and so, remains unconclusive. List as a part matter on 6/6/2025. Mr. Hazarika also is adding. HK Hazarika. See from the last order. Because at times these judgments, it creates dichotomy which at times don't meet. What happened was in this court, there was again a tainted recruitment process for police recruitment scam. And exercise was undertaken by the court to find out who are the tainted, who are not. This was interfered by the Supreme Court of India. He says that this should not have been done by the court.
Sadananda Haloi.
Hmm?
Sadananda Haloi report.
Sadananda Haloi.
2007, 7S.
So that's one. But even prior to that and after that, there are judgment of the Supreme Court which says that this fact finding could be done by the court.
We are, and Lordship, I bow to that because it's a reality. Because ultimately, Lordship, on a particular day, what is argued and what is impressed upon the bench makes a difference. Of course, we go by law precedents. But then one interesting thing that I have found finally, which has helped us through the years, through the Supreme Court judgments, is that that caveat does appear in the given facts of the case, looking at the peculiar facts of the case. So therefore, that's the protection that somehow is there. Ultimately, Lordship, then we sift through it and we rely on what works in that given set of facts.
Yes, thanks. You remembered it correctly. Sadananda Das. Sadananda Das was
2007, 7S.
He's been here for a long time, Lordship.
Hmm?
He's been here for a long time.
No, they were somehow involved. These people were hardworking even then.
Yeah, Lordship, and I must say that there are several of colleagues like him on the other side, whom I have had the occasion for almost now 6 years, Lordship, seeing them on a very regular case consistently.
2019.
From 2019 December, Lordship. So it's not as if we've not seen them.
Ms. Chaudhary is one. Ms.
Yes.
Prasad is one.
Ms. Chaudhary and our acquaintance is more recent because we entered in the other batch of matters. So my acquaintance with her has started now, but I have a feeling that acquaintance will be for a few years.